I'll call this meeting to order. It's already 6 o'clock. It's now 6 o'clock. It's Thursday, the 28th, 2023. I have forum here, Director Conley, Martel, Director Schott, Director Gaines, Director Ward, Director Bland. The only one that's absent is BJ Rod. So we're going to call this meeting into order right now. We're going to stand and pledge allegiance to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Heavenly Father, we come before you today, Lord, just asking for your wisdom, Lord, your guidance this morning. Lord, we ask that we leave here, all as friends, Lord, neighbors, Lord, that you bring the community together through this. Lord, we ask that if it's in your will, you bless us with rain. Lord, we thank you for everyone that is here represented, Lord. We ask that you grant them safe travels from wherever they've traveled from. Thank you for all that you do. In your name I pray. Amen.
Amen.
Yeah, I want to thank everybody for showing up today. This is a special meeting. One that's been, everybody's been anticipating to see what all's going on. So with the groundwater here in Kinney County, Dr. Hutchinson's here. Mr. Ellis is here. He's our attorney. So without further ado, we're going to get this started. It's going to go a little bit different than what we normally do. As far as the next item on the agenda, which is directors and public comments, we're going to save that until after. It's going to be one of the last items on the agenda. So Mr. Hutchinson can give a presentation. We're going to be able to conduct business, and then the comments and stuff will come afterwards. The comments will be subject to 3 minutes. Comments from people will be 3 minutes. Okay. So let's move. We're going to move from that item to the agenda to move this around. So actually, the presentation from Mr. Ellis, we're going to move that to number 1.
Thank you.
Oh, all right. You're going to get leave early?
Okay, I hope everybody has a copy of the draft proposed rules. Please understand, and don't repeat this, some of y'all work members want to look at it before, but because we have such a big crowd here, I want to make sure everyone understands the process. Number 1, I'm here to advise, maybe help educate. I don't decide anything. You all decide. If they're unhappy with what has been decided, you get to carry the weight of that, not me. All right? But I also don't want anybody saying, well, we did it because Moras said we had to do it. If that's not the case, you can do what you want to do. Now, there are things that you have to do because the legislature's told you have to do it. That's another matter entirely. That's kind of what I want to try to provide some education on. This last legislative session, talking about the regular session, not either of the 2 special sessions or the 3rd session coming up. This last regular session, we had a number of bills that were introduced dealing with groundwater issues, specifically the powers and duties of groundwater conservation districts. In fact, there were more bills filed this session than I can remember having been filed in any of the last almost 20 sessions I've been up there. Groundwater has become a very, very hot topic. The way of some history, back in 1997, the legislature passed Senate Bill 1, and that was a water planning bill in order to start to make sure we would have adequate water supplies now and into the future. It was a groundbreaking. It has become a model for the entire country to follow. But, like all legislation, had some good parts and some bad parts. One of the things I consider to be a bad part is the part that said that all of the surface water in the state essentially had to remain within that watershed. You cannot move surface water from one basin of origin to another basin without it losing its priority in terms of the permit it has. So I can have the oldest permit on the entire Colorado River system. If I moved it to sell to somebody in San Antonio, I now became junior to every other permit on the system, which meant I lost 90% of the value of that permit. The result of that is not one innovation transfer has been approved since that took effect in 1997. Instead, the entire focus has gone over to groundwater. Now, the one good thing about not having a lot of water is the cities aren't coming out here looking for water. But you might remember when this district first started, there were several applications. Specifically, there was one big application that was filed, and the goal was to pipeline that water to San Antonio. Now, that permit eventually went away. It was litigated over a long, long time. Eventually, they folded up the tent and went away. That doesn't mean it can't happen. So, some of the things that happened this last session, I hope will aid your ability to protect your water supplies. You cannot tell anybody who owns land and therefore owns the groundwater that if they want to sell it to San Antonio, they get to sell it to San Antonio. It's just doesn't matter if it's groundwater or if they put it in beer cans first and then sell it to San Antonio. It's the same thing. It's their property. They get to do that if they want to. What you can do is decide on how much water can come out, how fast it can come out, and the fees they're going to have to pay when they do that. So that's what we're going to talk about with these proposed rules. The first thing on the list here is called export fees. An export occurs anytime you're going to transport water from inside the district boundaries to outside the district boundaries. It's an open question as to whether or not that applies to otherwise exempt use. And if you have somebody who claims an exemption for the permit requirements and they want to start exporting water, it's entirely possible that you could charge those export fees to that entity or require them to come get an export permit, even though they don't have to have a production permit. And I'm not sure. There are a lot of, we have to have a long discussion about whether or not to qualify for the exemption anyway. There's the exemption that's being claimed here is a very difficult, nebulous one. So that part aside, if you have somebody who says my plan is to, and we had back in the 2000s, all the way through the 20 teens, they want to pipeline water to San Antonio. You get to charge an export fee on the amount that they're pipelining out. That fee has been changed, thank you to Tracy King and Senator Perry for carrying this bill, to 20 cents per 1,000 gallons transported. So, and that amount can go up by 3% per year, every year beginning of 2025. Okay, so you will set that fee. What this rule says is you're adopting that export fee. It comes in place of the export fee language that you had before, which was repealed by this bill. And but you're going to set the fee rate whenever you set your rates with your fee schedule. When you adopt the fee schedule, you're going to set what the actual rate is in that fee schedule. And this rule gives you authority to do that. Okay? So that's number one thing that happened was we got this export fee. The other thing that happened in that bill, and I think it's the next thing on the list. No, it's not. I'll get to it in a bit. Any questions about the export fee rates themselves?
You have a bill number?
I did, but after 20 different sessions, the bill numbers start to get mixed up. So I'll get you the bill number afterwards if that's okay. I think that was House Bill 3059 that did that one, but 3059. Nope.
Okay.
I could very well be wrong. Just got 15 bill numbers stuck in my head. Okay, the next thing, number 2 on this is amendment to Rule 307YC, and that has to do with what happens when you have a contested case on a permit. When somebody applies for a permit, first off, you have to have a public hearing, At the public hearing, somebody might come in and say that they want to protest that permit. If they protest the permit, that sends it to a contested case hearing, which is a lot like a trial, only through administrative law. You can either have that hearing before the board, you can have that hearing before a hired hearing examiner, which we've done in the past year, or anyone who's been admitted as a party, if they act at least 2 weeks before the beginning of the evidentiary hearing, may demand that the State Office of Administrative Hearings in Austin conduct the hearing. That takes it out of your hands, puts it in their hands, and they have to conduct the hearing. If that happens, the person who demands that hearing has to pay the contract with SOA. You still get to decide where the hearing is. You can decide if they want to have it conducted in SOA to save people money, and have all their attorneys that are coming out of Austin anyway, deal with it, and not have to pay for the SOA judge to come all the way out here. Or you can decide you want to have the hearing here. Now the hearing, that's unlike public hearings. It's just like a trial. The only people that get to speak and argue are the parties who have been admitted, and the administrative law judges make the final decision. What they're going to decide, though, is a proposal for a decision. They're going to say, we've looked at all of the evidence, we've looked at all the law, and here's what we propose you do on this permit. That comes back to this board. Now, you're not allowed to change the facts. You can't go look at this and say, well, their expert said X and our expert said Y. We're going to believe our expert, even though the administrative law judge believes their expert. Can't do that. But you can say the administrative law judges misread the law. Their interpretation of law is wrong. We're going to use this interpretation over here, and applying that interpretation, this is what happens on the permit. So that you get to do. If there are findings of fact that you don't find any facts to support, those you can just remove. If there are no facts in the record to support the decision of finding a fact, then you can remove that. Well, one of the permits the last couple of years that went through SOA was an application by the Lower Colorado River Authority to the Lost Pines Groundwater Conservation District. In part, and the main part, because this all happened during the COVID pandemic when people couldn't meet in person, that permit process took a little over 2 years. And Ellis was unhappy about that. The other problem with that is that they have a 10-member board over there. The general law in the state of Texas is that in order to take action on a 10-member board, you have to have a minimum of 6 votes. So not only do you have to have 6 voting members there to take action, you have to have 6 votes in favor of that action or nothing happens. So 3 of the 10 members of that board had to recuse themselves. They had conflicts and could not vote on that LCRA permit. That left 7 voting members needing 6 votes in favor of the permit. And at the time that we were doing this, I thought I had 2 members that wouldn't have voted to give LCRA a glass of water. Okay. Miracle of miracles, the eventual vote was 7-0, so we got there. But LCRA was still unhappy with the decision. They got 8,000 acre feet instead of 25,000 acre feet. And they're unhappy with that, so they filed a lawsuit over that. But what they also did is they got this legislation filed. What the legislation does is it puts any case that goes to SOA, the State Office of Administrative Hearings, has a hard deadline by which you have to take action. If you have not taken action, once a proposal for a decision comes out, if you have not taken final action by the 181st day, that proposal for a decision becomes the decision. It supplants you entirely. It takes you completely out of the process. Now, I worry that there might be some boards out there that they're perfectly okay with that, because then they don't have to take the blame. They should put it all off on the administrative law judge. I hope that's not the case. It doesn't happen very often. And 180 days is a long time. Any board ought to be able to come to a decision in 6 months and make a decision and vote on something, whether to grant permits or how much. So, but that's the first thing. It says that 180 days. The next part of this, the third rule amendment, is 307 sub Z. That has to do with rehearings. One of the things that we were worried about when they set that 180 day limit is that people would use motions for rehearing or other legal maneuvers in order to try and delay at final action past that 180 days and try and claim that they got their proposal for decision from the ALJs as their permit. So we put limits on the motions for rehearing. The parties can only file 1 motion for rehearing. If there are multiple motions for rehearing from multiple parties, you combine them all into 1 decision. And that's the only one that they can ever file, that you can't be a motion for a hearing and followed by you grant it, then make a decision, then another motion for a hearing. You grant that, make a decision, another motion for a hearing. That's not gonna happen. There's one time, one motion for a hearing, it's all combined into one hearing. You do that, and then you make a decision after the motion for a hearing. If you don't take action on a motion for a hearing, on the 91st day, that's deemed denied, okay? So that's the same thing as voting not to accept the motion for a hearing. So that's all that we have there in 307Z. That's the third proposed rule. There are some limits on what, how soon you have to schedule it. If you grant it, how soon you have to schedule it, and other things like that. But that's not a lot different than what you already had in the law, which had to make it shall instead of will. The fourth one on here is amending the rules. This was a big deal from the Texas Farm Bureau. I wanted to make sure. I've always had the opinion that anybody can come in anytime they want to, walk in public comment and say to the board, I would like to have a new rule to say this, okay, and propose that rule to you. That, to me, that's the same thing as petitioning the board to make a rule, and you can either do it or not. Well, they wanted to put some requirements on that. So they said, if somebody brings you a petition for rulemaking, then you have to take action on that within 90 days. The action can be to deny, say, no, we're not going to do anything about it, or it could be to say, well, let's go ahead and start a rulemaking process. There's nothing that requires you to adopt the rule that they have proposed. Even if you propose the rule, you can get public comment on it. Everybody can come and say, I hate that rule, don't do it, and you can decide not to do it. Or you can simply say, we don't like the rule, start from the get-go, we're not going to propose it, and decide not to. One key provision in the statute is all governmental bodies in Texas, including groundwater conservation districts, have governmental immunity, meaning you're immune from suit unless the legislature has waived that immunity. Well, the waiver in Chapter 36 is pretty huge. Anybody dissatisfied with any decision made by the board has the right to sue that board. Now, there are some other limitations in 36. For example, a permit decision, the only people that can appeal a permit decision are the people who participated as parties in the underlying contested case hearing. So anybody can't come in and file a lawsuit over a permit, in my opinion. So what this does is it says, if you decide you're not going to adopt or grant their motion to start a rulemaking procedure, or you don't adopt the rule, that is not something that they can sue you for. Very plainly said that it's not something that can be brought up for lawsuit. So someone can't decide they're going to cause you heartburn by bringing you a petition, having you deny the petition, and then file a lawsuit against you because you didn't accept the petition. They just simply can't do it, but they can bring a petition. Now, one part of this I want to point out, because this part's really entirely up to you as to what it says. In that list of things that you have to have in a petition, the law says a person with a real property interest in groundwater in the district may file a petition with the district to request the adoption of a rule. But then later the law says the district gets to set the requirements of that petition. So I put out here these 5 different requirements. The 5th one says signed by at least 50 persons at least 18 years of age with a real property interest in groundwater in the district. The reason I put that in there, that 50 is just a suggestion. The reason I put that in there is because I don't think we want an oil company petitioning for rulemaking every month. We don't want, somebody who just wants to mess with the district petitioning every single month for rulemaking. You want to have some support for it. Now, the reason I set that at 50 is because the water code allows the district to consider a petition to change its boundaries if that petition is signed by at least 50 people. So I don't think you should go over 50, because if you can change the boundaries of the district with only 50 signatures, I think you ought to be able to change the rule with only 50 signatures. If you want to make that a smaller number, you certainly can. It could be 40, it could be 10. You can make it one person if you want to. We could simply strike that section out entirely. My recommendation to you is you leave it in there for the proposal, get some public comment on it. After you hear the public comments, you can decide whether you want to keep it or not, and whether you want that number to be 5 or 50. Okay? So that was the fourth thing, and I think that's the last thing we have on the list here. There was one other big change that was made, but your rules are already generic enough on that. The big change was they've expanded the exemptions from the permit requirements to cover a rig supply well that is supplying water to drill a water well. Now, the exemptions already have allow for someone who has a rig supply well to drill an oil and gas well is exempt from the drilling permit requirement. This adds a new drilling permit requirement exemption if they're using that smaller well to make drilling mud to drill a bigger production well. I don't think it makes any difference. Every client I have that I know, when you issue a permit to drill a big production well, and they say, I've got to drill a water rig supply well, that's part of that permit. They get permission to do that part of the permit. There's no reason for you to say to somebody, yes, you can drill a 36-inch hole. No, you can't have the water you need to drill that hole. So, but apparently somebody did someplace in the state, so we have a new exemption. Your exemption flat out says, our exemptions follow chapter 36. So because that exemption is now 36, that exemption now applies to your rules. You don't have to put it into your rules. Most of our other clients have listed out all of those same exemptions. Some of them have expanded them. For example, one client I was just talking with today, their exemption on the 25,000 gallons a day for domestic and livestock use, they've changed it to 35 gallons a minute. 35 gallons a minute, which is really 50,000 gallons a day. So they doubled the size of the well that you could use and still get that exemption. But you haven't done anything like that. You simply follow the same exemption as 36. All it does is cite the 36, so you don't need to make a rule change to do that. There were a lot of other laws that passed that I can tell you about real quick. And many, many more that didn't pass. There was a bill that passed the House. Didn't even apply to Groundwater Conservation District. That was amended in the Senate so that it did apply to Groundwater Conservation Districts and all other water districts in the state. And it would have said that not only do you have to post your agenda on the website if you have one, but you have to post all of the materials provided to the board as well. Now, if they had limited that to materials provided by the staff or consultants to the board, I don't think that would have been a problem. That's not what it said. As it passed the Senate, it said all materials presented. Well, I'm sure y'all have been following the news. People have walked into school boards, and one woman came in and presented every one of the school board members with a Bible. Said, clearly, you all need to read one of these. Technically, we would have had to scan the Bible in and post it to our website if that law passed. Had another person walked in, and they walked in with a Hustler magazine, and they said, "Is this the type of material you think we should have in our schools?" You would have had to scan the Hustler magazine and post it to your website. So, fortunately, we got that fixed. So the law still does apply to Groundwater Conservation Districts and all the water districts, but now all it says is, in addition to posting your notice of the meeting, you have to post the agenda with it, and we all do that anyway. That's what we use to post. So we dodged the big bullet on that. There was another bill that was filed. Senator Perry has continued to carry the same bill session after session. That would have removed the advantage that the district has in terms of getting its attorney's fees in litigation. Right now, if you're involved in a lawsuit, if the district prevails on any issue, you're entitled to compensation for whatever attorney's fees you had to spend to prevail on that issue. If the other side prevails on any issue, they don't have a like thing against the district. It's not a loser pays. Senator Perry thinks about a loser pays. Maybe he's right. Chairman King, who's the chairman of the House Water Committee, is adamantly opposed to that provision. So Senator Perry files it, passes it out of the Senate, goes to Chairman King's committee, and he kills it. Now, I bring that up because Chairman King is retired. He's not running for re-election. So he will not obviously be chairman of the committee next time. We have no idea who will be chairman. We have no idea if that person is going to be for or against that provision. So that provision might come racing through the legislature next time. I have no idea. But that was one of the things that we've been talking about for at least 4 sessions now. And to his credit, Senator Perry has backed off more and more each session up until the last 2. And right now, it really only applies to if the district gets sued by somebody claiming a violation of the Constitution or something like that, then the judge may award attorney's fees, but it's not required to award attorney's fees. But he left alone the provision on defending permits and the provisions on enforcing your rules. If you're going to take enforcement action against somebody, you're pretty much guaranteed to get your attorney's fees when you prevail. So his bill leaves that alone. So it's got a whole lot better than it was when he originally filed it. We'll have to see what he files next session. So those are the main things I wanted to mention to you. And what you have in front of you is a set of proposed rules. Again, you can take action tonight to propose these, publish them, come back and call a public hearing for the next time that you meet. It has to be published for at least 20 days before you can take action. And you can have you need to have a public hearing on these proposed rules. If at that time you want to adopt them, you can. If you don't want to, you can, as long as you don't make a substantial substantive change to what the rule does. You can change it to say what you want. Like, for example, if you're to change that 50 down to 25, that's not a substantive substantial change. It makes it easier for them to do that petition. So that's where we're at. I'll have to ask and answer questions on that.
There's been a lot of debate about the definition of what is real property interest recently.
Could you speak up, please?
There's been a lot of debate about what is real property interest lately.
When you own the surface estate, then you have an ownership, the vested property right in groundwater beneath that surface. Not in any particular amount of water, which is confusing, because vested usually means absolute known quantity, but not in this case. So there's groundwater down there, the surface estate owner owns that groundwater. And that would be unless, just like with oil and gas mineral rights, unless that groundwater estate has been severed and sold to somebody else or leased to somebody else. If it has, that person has a real property interest in that groundwater. If you have an oil and gas agent, if you own the mineral rights, the mineral right lease almost invariably says, and by the way, I get to produce as much groundwater from your property to capture those mineral rights. So the oil and gas companies and the mineral rights companies all have a real property interest in the ground. So, it's kind of hard to think who doesn't have a real property interest in the ground. Because everybody who owns land over the aquifer, everybody who owns part of a groundwater right over the aquifer, everybody that owns a mineral right that happens to be near an aquifer, I think they all have a real property interest in the ground. Can you give me an idea what the confusion has been where somebody might have?
Well, I had heard that, different things like the citizens of the community, if they have a public interest in groundwater.
As a matter of fact, I would say the exact opposite is the case, because what the law says is when before somebody can show that they have a personal, justiciable interest in an item. For example, someone files an application and you own a well or you own property that you think that operation of that well is going to impact your well, that gives you a personal justiciable interest that you can then protest against that permit being issued to that person. But if you're just a member of the community and you say, I think this is going to overall be damaging to the community, that's already represented by the members of the board. You represent the community. So that is not a personal justiciable interest that would give you standing to go file that lawsuit. There was a situation similar to that in Bastrop County. A group there called the Environmental Stewardship owned property that didn't own a well. And they tried to protest the permit, and they were not allowed in as parties to that permit. So they filed an appeal of the decision not to allow them in as parties. The district court judge said, no, you don't own a well, therefore you don't have any real interest in the operation of these other permits. So no, you don't have standing. You don't have a personal justiciable interest any more than any other member of the general public has. The Third Court of Appeals heard that on appeal, but didn't ever get to that issue because they decided that they had not timely filed the appeal in the first place. So they didn't have the court didn't have jurisdiction to hear it to begin with, and so they kicked the whole thing out. That was the end of that lawsuit. might be hearing about problems going on over in the Pecos Groundwater Conservation District over Fort Stockton. Fort Stockton Holdings has a 50,000 acre foot permit and a transport permit where they can take 50,000 acre feet off their land, transport that up and sell it to Midland, Odessa, San Angelo, and whatever points north they want to go to. The Cockrell family, who is right next door, and just as wealthy, by the way, as the Knight Williams family, maybe wealthier, has been fighting that ever since there was a court settlement that granted that permit. To their detriment, the Cockrells did not file a protest against the original permit. And because they didn't, the district court judge has routinely said, you do not have any standing to come in and fight over this permit. It's too late. You don't file a protest before it comes up, there's nothing you can do about it. You can't fight the renewals. The renewals are automatic. What used to happen in 2015, legislature passed a bill saying when you come in to renew the permit, if you're not changing anything about that permit, the renewal is automatic. It was a ministerial act, the general manager just doesn't. So they keep, every time that they're about to have another renewal, the Congress will file a lawsuit. Every time they file a lawsuit, when it gets appealed to the 8th Court of Appeals, the 8th Court says you didn't file it on time. Apparently lawyers can't count. So wrong number of days before you were supposed to file that lawsuit. So we're kicking you out as not having jurisdiction. This last summer, they filed a declaratory judgment action rather than appeal of a decision not to allow them to challenge that, and they're challenging the rule that allows the general manager to approve those renewals automatically. And we'll see how far that gets. At least it won't be thrown out on the appeal deadline. So we might get an answer to some one of those questions from that. But yeah, no, the general public generally doesn't have anything other than their vote and their ability to come and talk to you all. Any greater than any other landowner might have, or anybody else, especially non-landowners have, than to say that they have an interest in that groundwater.
Excuse me, would I have to be able to ask a question?
That's up to the chairman.
Make it short.
So the Suzanne made, the question I had was, so can, for example, the city of Brackettville, with their well, demonstrate a real, what is that term?
Personal justiciable interest.
Yeah, or, for example, could the Fort Clark Springs Municipal Utility District demonstrate? Do they fall in those categories?
Do they have a well?
As an interest, yes, they each have wells. As an
Do they have a permit from the district?
Or Clark has a permit.
Fort Clark has a permit, city of Brackettville does not have a permit.
Exempt.
Well, they claim it exists. Has never been tested.
But it's been wide open.
Very interestingly, in the water code, when there's a list of things the board has to consider in whether or not to grant somebody a permit, the impact on other permitted wells is a listed item. Impact on exempt use wells is not. That bill has been filed every session for 3 or 4 sessions and has failed to pass. So I would say Brackettville, despite the ownership of their well, doesn't have a permit, therefore has no standing or personal justiciable interest in a permit because we can't consider the impact on exempt use wells when considering the permit. Fort Clark Bud owns a well, has a permit, absolutely they have the right to come and down. If that well is 50 miles away from where the permit's at, you're going to have to prove that pumping somehow is going to impact your well. If you can't prove that, then no, you don't have personal justiciable.
Yeah, I understand. I just was trying to distinguish what other possible entities within our county would have that particular.
And
Thank you.
I've given you my legal opinion. That doesn't mean I'm right. I was wrong once before. Remember that presumably the 9 best lawyers in the entire country serve on the United States Supreme Court and routinely disagree 5-4 is what the law is. And if they can't get it right, it's kind of hopeless for me, I promise. So if that were to come up in the case, the administrative law judge or the hearing examiner might rule yes, they're standing, and might rule no, there's not. When that gets appealed up to a district court judge, that judge might agree or disagree with what the ALJ did. So I'm right until the judge tells me I'm wrong.
I have a question.
Yes, ma'am.
Boy, you talk fast.
I've been told asking me about groundwater is like taking a drink from a fire hose.
I know.
I apologize.
No, I'm the same way. I'm just, anyway, but, so help me understand this. So there's a potential for lawsuits for the owners of land that has groundwater under the water underneath it, and I'm not getting my terminology right, so I'm not. What about me and us? We bought places that are on water, right there at water. Why? So is the lawsuit potential only for the guys that, get reprimanded for pumping too much water? But what about our property values? Can we not sue about that?
Well, first off, anybody can sue for any reason.
Sure.
Okay.
Yeah,
Whether or
Judge
not-
Judy
whether
will
or not-
tell you that.
Whether or not prior courts have held that there is standing for any type of cause of action, there's another matter entirely. But if you want to file a lawsuit, go file a lawsuit.
Really, that's all?
Texas water law is unlike any other state in the union, but that a whole lot of Texas law is like that. We're a different state of mind. Who owns the water and whether or not you have a right to sue whomever or whatever depends upon what state that water is in at that particular moment. Water falls down on the ground as rainfall. It's diffused surface water. That belongs to the landowner where that rain fell. You can gather up as much as you want to. By the way, that is not true, for example, in the state of Colorado. As that water is falling into Colorado, it becomes the property of the state of Colorado. You have to get permission from the state to have a rain barrel on your house. Okay? So the diffused surface water belongs to the landowner. As soon as that flows into the bed and banks of a defined stream bed, it now belongs to the state of Texas. The stream bed and all the water in it belongs to the state of Texas. Every stream, every lake, everything in the state of Texas, that's all state of Texas water. As soon as that flows across a recharge zone, goes underground, well, now it belongs to the landowner. It happens to be under their surface property at that moment. It just changes from owner to owner to owner as that molecule of water passes on through. As soon as it comes out of the springs, it's no longer the groundwater district's problem. It's now back to a surface water issue.
But it's not gonna come back out of the springs.
Well, a perfect example of this was Texas versus Burton. It must have been the 1950s because that's the travel record and the people were fighting over water. There was a spring that flowed and created the headwaters of the stream. And Mr. Burkett went and drilled a well feet from where the spring came out and diverted all of that spring flow to his well. So the spring's completely dried up and he was taking it out of his well. When other parties down along where that water used to be said, we have water rights here, we have property rights here, filed a lawsuit to say he's stealing our water. The court said, if it came out of the springs, you'd be right. It's not coming out of the springs, it's coming out of his well, that's his property. Rule of capture is very, very strong in this state. Rule of capture is, I own everything I capture 100%, and I can pump as much as I want with impunity, regardless of what damage it might do to you. I used to tell people that the rule of capture meant you get to pump as much water as you want, regardless of how much damage you do to your neighbors. And they went, that's a great rule. I like that rule. So I changed it. The rule of capture means your neighbor gets to pump as much as they want, regardless of how much they damage you. That's a terrible rule. But that's the law, and the only protection that you have against that rule is a groundwater conservation district that can issue permits and manage withdrawals. Yes, sir.
I have a related question for that news from, thank you for being here.
They're paying me to be here. It's not, I'm happy to do it.
Thank you for our questions.
Sure.
I do have a comment before my question that was at the top of your presentation. You mentioned San Antonio being interested in buying water here back in the early 2000s, and that people may not be interested because there isn't water to be sold here. But many of the people in attendance, and I think the board knows that there are 2 water marketing groups in Kinney County currently, and they are mentioned in the City of Laredo's water plan at this moment if you look at their website. And that's just a comment. But my question for you is regarding the power of the groundwater districts in Texas, and specifically to approve an export permit. And referencing other groundwater districts in Texas, their district rules. I know that they're required to review the all available groundwater and the impact to other people in the county, regardless of whether they're permit holders or not, as well as the desired future conditions that the district has set up to that point. And they are given the jurisdiction by the Texas Water Code to deny an export permit based on those parameters, and that's common in many rules. And I would ask you to elaborate on that and the power of the district to deny a permit. And I have confusion around the contested case hearing. If the district does exercise their granted power through the Texas Water Code to deny an export permit because that water doesn't exist to be sold because it would harm other people or surface waters that are protected by the desired conditions, would a contested case permit still be able to be forwarded by the person trying to apply for the export permit?
Anytime somebody asks for a permit, it's subject to the contested case hearing process, whether it's to be granted, denied, or whatever. It can be protested by other people, specifically other well owners. The board, if they grant a permit but grant less than was requested or put some other conditions on that permit, the permittee can demand a contested case hearing. And that's, you want a contested case hearing because you want to fully develop all the science, all the facts, get all of that developed in a trial-like process. Because once the district board is finished with it, when it goes up on appeal to a trial court judge, you don't get to re-argue the facts. That's an appeal, just like an appeal from a district court judge to an appellate case. That is the facts have been set, the decision has been made, and the only thing that the district court judge can do is review what the district did, and if he or she decides they got it wrong, remain it back to the district and say, try again.
And can you help me understand as an attorney, since the Groundwater District is awarded that power to be the supreme governing power of groundwater in Texas, what could someone applying for an export permit possibly forward or present that would override that supreme power that's awarded to groundwater districts if they choose to make that decision to deny the permit?
Great question. Please understand that groundwater conservation districts are literally walking a razor-thin line in terms of protecting private property rights. On the one hand, you have the private property rights of the landowner who wants to pump that water and transport it, sell it, turn it into beer, whatever they want to do with it. On the other hand, you got the property rights of everybody else who's going to be impacted by that level of pumping. In Milam County, there's a very large well field that feeds water into the Vista Ridge pipeline that goes down to San Antonio. I can't remember how much it is, but it's tens of thousands of acre feet a year. That pumping over the last 3 years has dropped some wells in Lee County 180 feet. And those people are rightfully unhappy with that. The rule of capture says, tough luck, too bad for you. Your solution is to drill a bigger, deeper well for yourself. If a district says, no, you may not have your permit, number one, they have to base that on the science and the facts presented to them and the law as they interpret it. If they just say, no, we're not going to do it, that's automatically arbitrary and capricious, and the court's going to overturn it. So they have to find a way to find the law and the facts that support it. When they do that, that potentially opens the door for them to be sued for taking of their private person's private property, along with other challenges. Bandera County River Authority Groundwater District received applications for 2 wells, total of 200 acre feet. The Vanderbilt Company said one well is going to be used to supply water to a house, the other one to a barn. The general manager went, if it's only going to go to a house and a barn, why do you need 200 acre feet? That seems like a lot. I'll give you the same amount. Those are both exempt uses. You could have got exempt wells for that. I'll give you a permit for the same amount you would get for the exemption. which is 25,000 gallons a day or 28 acre feet a year. So if you put 28 acre feet on each one, that's his recommendation. The board followed the recommendation, voted to issue permits. Vanderpool was unhappy with that. Is their right demanded a contested case hearing, or granted the contested case hearing. They then demanded a SOA hearing. The administrative law judges at the state office of administrative hearings to hear it. The board granted that request. In between those last two things, they filed a federal district court lawsuit claiming the district had taken their private property, violated their civil rights, violated equal protection, violated due process. And to their credit, the district filed an immediate, what's called a 12B motion, which is a motion to dismiss in federal court. And fortunately, the district court judge, in my opinion, got it right and said this matter is not ripe for adjudication because the final decision is not made yet. Go get a final decision and then file a lawsuit. Well, if that district eventually grants anything less than 200 acre feet, unless it's done through some sort of agreed to settlement, Vanderpool's going to file a lawsuit, and we're going to have to defend that lawsuit. And what's going to happen when we defend that lawsuit? I don't know. You know, I think we can probably defend it, but it really depends on what decision the board makes and whether or not we have the facts and science to back up what we did. If they said absolutely no, you may not have a permit at all, that would be much tougher. In the 2012 case, where the Supreme Court denied that that's a vested property right, they said denying a landowner all rights to capture their groundwater should result in the taking of private property. Now, how much the damages are is another matter entirely. But the court said that every landowner should have a right to produce some amount of groundwater.
Could you talk just a little bit more about a question about the district's power to respond to a situation like that? What powers they have granted by the same Texas legislature?
Okay, the board may consider impacts on other permitted well owners. They can consider, as part of the planning process, they can consider impact on spring flows. They can consider overall aquifer health of well owners. They can consider the amount of recharge coming in. They can adopt drought rules that restrict pumping under certain conditions. But again, and this is especially true out here where you have such a large irrigated crop community. If you restrict usage of groundwater during a drought when they most need it, you're probably killing crops. If you're killing crops, you're probably not going to be subject to takings liability for killing crops. At least the lawsuit. I don't know whether the person's actually going to be liable for that or not. The district might be liable for that or not, or what those damages might be. But I can promise you the lawsuit will be filed. And I can, in my prior history, from 1997 to 2004, I was the first general manager of the Edwards Aquifer Authority. So I did a lot of that. Did a lot of drought restrictions. One of the things that statute says, if you didn't have a well by 1992, you could never have a well. There was a lawsuit filed over that, but it was 17 years after that rule took effect, so they didn't get very far with that. And those same 5 people filed that lawsuit in 1998 or 2000, they probably would have won that lawsuit. That would have completely upset the entire Edwards Aquifer Authority scheme of regulations. Give me 1 second while I finish this. I want to get back to the export point.
Sure.
36.122 of the Water Code says you may not treat people who are exporting groundwater any differently than you treat anybody who's been using water inside the district. The rest of that statute then talks about all the ways we have to treat exporters differently than we treat everybody inside the district. For example, we have to give them, once they've built their started building their transportation system, which might be a picture of a guy with a shovel moving some dirt. I started my work on the transition system. I now get a 30-year permit. Nobody inside the district gets a 30-year permit. Now that's a 30-year transport permit or export permit. It's not a 30-year production permit. I've always argued they get the same production permit that every other person inside the district gets. And if the production permits, the first comes to shove, and this body decides we're cutting all production permits by 25%, exporters get cut just like everybody else does. Now, if they were to cut the Vista Ridge permit by 25%, that would very likely result in a lawsuit against that district for taking their private property and their investment-backed expectations in $1 billion pipeline that they have to keep full, because if they don't keep it full, it will start leaking and sucking itself into the pipeline, making that water unusable. So once pipeline's built, it's very, very hard to say no or not as much as you want. If you're going to do anything like that, you have to do it under a transition. Now, one other quick example, this doesn't do with exports, but this is power of a groundwater conservation district. There are two very specialized groundwater conservation districts in the state. They're both subsidence districts, are both in the Houston area. Harris, Galveston, and Fort Bend counties are covered by subsidence districts. They have required people to reduce reliance on groundwater, where I live in Galveston County, by 90%. That's 9-0. In all the rest of that area, they required them to reduce their reliance on groundwater by 80%. Now, they don't do anything about that until that person has an alternative water supply available, or if they're pumping more than 10 million gallons a year. In either case, if they either are required to go find an alternative water supply, if they don't, then they have to pay a disincentive fee. Right now, the disincentive fee rate, I think, is $10.50 per 1,000 gallons. So that creates an economic incentive to go find that alternative water supply. But we also have subsidence on the other side. Every takings case is a balancing test. What ill are you trying to correct with your regulation? And how bad is the regulation on the individuals who are impacted by it? Well, if I have to pay more money for water, and you compare that to, I'm keeping this property over here above sea level, this one probably wins. Y'all don't have subsidence in this area. You do have spring flow in this area. You do have, other issues that you have to look at. So, how would that balancing test come out here? I'm sorry, I don't know. I will tell you this. I will defend whatever decision they make. Whatever it is, I'm here, I'll provide them advice. They will decide, and I will defend whatever decision they make. Yes, ma'am.
Okay, again, what about my investment? But more importantly, what about our environment? What about the habitats? What about the interesting creatures that reside in this area and other areas that are undergoing the same sort of thing? Their habitats are diminishing. I mean, I hate to be a broken record, I haven't seen the Rio Grande beaver in 2 years. So we are having a problem. We are having a problem
When
with
you're talking
the
about,
health of the Lost Moras Springs.
That's it.
And anybody that wants to say differently, please raise your hand right now.
when you're talking about endangered species,
I'm not talking about endangered species. I'm just talking about species. I'm just talking about.
they sounded like they were endangered by what you said. But federal law does trump.
No, I'm talking about the kingfisher. We have all 3 species here, which is nice that they have in North America. And I know the board's heard this the last time. But where are they going to go?
Okay.
Where are they? What are kingfishers eating?
Okay,
Anybody have an idea?
let me try and answer your question. Okay.
Thank you. I'm sorry, but
Let me-
that's huge.
Okay. Remember, I can't hear or answer if other people are talking at the same time somebody else is talking. So please don't do that. This isn't a Republican debate. So, starting with endangered species.
I wasn't talking about endangered.
I understand, but I'm starting.
Okay, thank you.
Starting with endangered species, they have federal law protection. That's how the Edwards Aquifer Authority was created. If it hadn't been for the endangered species, I'm not sure that the Edwards Aquifer Authority would even exist. But the federal judge, Judge Burton at that time, said, legislature, if you don't do something to get this under control and protect those endangered species at those springs, I will. And the legislature created the Edwards Aquifer Authority, and they started their permitting process and put together their recovery implementation plan, and that dealt with all of that. If they're not endangered species, Texas really doesn't care.
Well, I do.
I understand, but you're asking me legal questions and what statutes and other indications say, okay? And I'm gonna tell you the hard truth. Texas, they don't have the same kind of protections for federal registered species of any kind. And when the Cipriano and Fain family in 1997 had wells go dry and had springs go dry because of what they blamed was pumping by the Ozarka company as the Great American Springs Company. They were pumping water out, putting it in trucks, trucking it to Fort Worth and bottling it up to sell as Ozarka bottled water. They said that their pumping caused those springs to go dry, and so they filed a lawsuit. They actually approached me, the Fains and Ciprianos and their group approached me to represent them in that lawsuit. And being young and stupid at the time, I said, you can't win that lawsuit, rule of capture, it's all decided, don't bother. So they went to a young lady who'd been out of law school a year and a half. She took the case. She lost at the district court level. She lost at the appellate court level. She filed a petition with the Supreme Court, and she got to go argue in front of the Supreme Court instead of me. So that shows you how good a lawyer I am. In that case, however, the Supreme Court said, rule of capture stays for an hour. And the rule of capture means people who are pumping groundwater get to dry up other wells, they get to dry up springs. That the groundwater is the exempt pumping. The person using groundwater has more rights than anybody else in the state in terms of water. That's just how the law has worked out.
Except the board, correct?
The board has the ability to set regulations subject to takings liability and other issues. So yes, the board can flat out say no, and then see if they can win the lawsuit.
So Bill, I have one other thing to say from the Kinney County Post, I believe it's Hutchinson has also maintained that pumping does not hurt the spring. Although in his studies, he wrote, in general, pumping increases result in reduced spring flow, and reduced pumping results in increased spring flow.
Okay, that's not a legal question, and I will let Mr. Hutchinson
No,
answer
it's
that
not
during his
a legal question,
presentation.
but it's,
But I will let him answer that during his presentation.
Thank you.
Okay. Yes, sir.
Isn't it right whenever the EAA did, whenever the federal judge said, better make this decision or else we're gonna step in? The reason why the spring was put in was because of the endangered species, correct?
Absolutely.
Otherwise, the springs would have been left out.
Absolutely.
So all the rice, out in there.
There are multiple
There's multiple.
endangered species.
That's why the spring was included with the EAA.
And as one lawyer put it, on the one hand, you had the rule of capture, which looked like King Kong. On the other hand, you had the Endangered Species Act, which looked like Godzilla. And they kind of met, and that resulted in the birth of the EAA. Without the endangered species, EAA probably never would have existed. I thought there was another question. Yes, sir?
Well, kind of like, so the board, are they allowed to limit pumping? Not
Absolutely.
But limit pumping
Absolutely.
in order to protect artesian pressure.
Yes, absolutely. But if they limit pumping to the extent that they have made that well owner's investment back to expectations harmed, they're potentially liable for that takings.
Okay.
hey, I could sue them.
And, sorry, go ahead.
I just gonna say they have the legal right to do that, but there are always these other boundaries on how far that legal right goes. And until they do it, and we have the lawsuit, and the judge tells us how far those boundaries are, we don't know.
Okay, so it's a balance. If they have the right to do it, it's a balance of how far is too far before you damage someone's property in an
That's right.
unreasonable way.
And what courts have said on how far is too far is the same thing that's said with obscenity. I know it when I see it.
Okay.
Which helps us absolutely not at all.
And then a follow-up question, can the board cancel a permit for not following board rules?
A board can take, the board can take enforcement action against anybody who violates the district rules.
And would the
And that can be, because a permits come up for renewal periodically, you don't, if there's a violation, outstanding violation, you do not renew that permit. That's the first big hammer we have. We're not gonna renew your permit. The second big hammer is we can file a lawsuit. That lawsuit, we can get an injunction against your further operating of that well, or we can get up to $10,000 per day, whatever amount the judge decides, for every day that you continue to violate.
Okay. And the board is able to make their own rules within the law.
As long as they're falling within the statute, that's exactly right.
Thank
you. Right?
The changes that you're proposing, the board, you're recommending, have they seen them before now?
I probably not a lot. I think I sent them to Janelle the day before yesterday, and I had to make a correction to it this morning. But all they're doing is proposing, and they don't have to propose it tonight. They can wait till the next meeting to propose if they want. But I was gonna have, I knew I had to be here for this tonight anyway, so I want to make sure they got this done. The one thing I want to say, Bill, is the petition for rulemaking, that there's a deadline in the statute. You have to have that rule adopted by December 1st. So let's make sure they get proposed and adopted before December 1st. Yes, ma'am.
I have a couple of questions. I'm like this young lady over here. I don't understand everything.
I don't understand everything.
The thing is, who is responsible for the Fort Clark Springs? Is it Kinney County or is it Fort Clark?
I'm not sure what you mean by responsible. Who's in charge of trying to make sure the water continues to flow out of the springs?
There's no water flowing. It's very disappointing. I have been at Fort Clark or I've owned properties for 30 years. This year I come back, everything's dry, there's dead fish in the creek, stinking the houses right. I've asked the people, so it smells.
Right.
It stinks. And not only that, but I walk around the site and there's hardly any deers when there was abundance. Now I want to know if they can put a limit on the water. I'm pretty sure you do, because I do pay for water from the faucet, take a shower, okay? And I also pay taxes and fees for that. Someone has been coming, allegedly, and taking some water from the spring. The spring is just dry. Even where the spring was dry. It was so sad. It was very disappointing. For people that have been there for that many years, they know what I'm talking about. But nobody knows what to do. Nobody tells us. They don't guide us or tell us. I've tried going to the office. Well, we don't know. They're the ones that give me the date and time of this meeting. That's why I'm here. But otherwise, I don't know who takes care of the spring. Oh, we don't do that. Well, then I come to Kinney and no. Well, who is getting what? Somebody better be getting paid for that water, because we're not getting reimbursed, and we're getting, taxed and extra fees at it, and talking about San Antonio.
Let me answer your question first, okay? I'll let you continue, but let me answer what you just said. Number one, there's no statutory requirement at all that this district or any other district protects spring flow other than the inverse aquifer.
That's ridiculous.
No. Did y'all hear that? Whoever this is,
Number two, assuming it's pumping that's causing the springs to go dry. Which again, that's his question, not mine.
Springs?
I'm going to say, assuming that's the case.
Assuming,
How about the drought?
Okay, let me finish what I'm saying. So, ma'am, it's not.
I want to call this to order. Ma'am, you're going to let the attorney answer the question.
Okay. Under Texas law, the rule of capture trumps spring flow. Meaning, if pumpers are drying up the springs, it's their right to do so, and there's no liability for having done so.
does IRS know this stuff?
Now this board has adopted a standard where one of the goals they have is to make sure that the average amount of spring flow coming out of Las Moras Springs is over a certain number each year. There's an average for the entire year, right? Is that right? There's the number at the end of the year? Okay, he's gonna get with that standard. So they have looked at that, they have said this is a priority of ours, and now the question is, what, if anything, can they do about it? And if reducing pumping will help continue the spring flow, then they have to look at whether or not they can achieve that pumping reduction, and if doing that's going to cause them to cause someone to sue them for takings like that.
Okay, who is that person we need to talk to?
Those are all the decisions. That's all the decisions this board has to make.
Okay, somebody's taking the minutes. Now, how come San Felipe, spring has water, and how come Uvalde has spring water? We're right in the middle, and we have no water.
Again, that's not a question for a lawyer, that's a question for a hydrogeologist, but I think it's probably because you're sitting up on the watershed where the water goes both ways out of Kinney County. Close? No.
Okay, now,
He promises not to answer any legal questions, I'm gonna promise not to answer any more hydrology questions.
okay, now, I'm from San Antonio. We are in stage 2 right now, stage 2 level. I walked into Fort Lauderdale and I said, this is like stage 4, because we have little cities around San Antonio that are on stage 4 water level. That means that you're very limited to what you water, what you don't water, and stuff like that. And then I come here, and it's dry, I mean, and you're saying that San Antonio wants water from you guys? I haven't heard that at all. And I like to listen to CNN and WOAI and stuff. I have not heard that San Antonio has been wanting water.
Well, to be clear, San Antonio has never expressed a direct interest in pumping water out of Kinney County. There have been people that have expressed an interest in selling water to San Antonio.
Oh.
And San Antonio's never bid on it except that's why that one permit eventually went away. They couldn't sell it to San Antonio. Now, apparently, I guess there are some other entities that are interested in selling water to other cities in the area. We'll have to see if they go for it or
It's
not.
like you said, we have to be very careful with the water. I mean, that is a necessary.
We do, but once again, I want to reemphasize this. If I own property in Kinney County, and I own the groundwater beneath that property, and I want to sell that groundwater to San Antonio, Laredo, or a beer manufacturer, put it in little beer cans and send it out, I have a right to do that. How much I can take is up to this board. How fast I can take it is up to this board. Whether or not I have to reduce taking it during a drought is up to this board.
It's screened.
But this board only regulates the pumpers. So when you talk about stage 1, stage 2, stage 3, those are drought restrictions implemented by municipalities, not groundwater conservation districts. Those are not EAA rules. EAA has stages that they limit how much can be pumped. Those rules are on the pumpers, but not on, so for example, I don't think this board has the authority or should adopt a rule that says, okay, we're in this stage, you can no longer water your lawn.
Now, do we have
Because they don't regulate lawn owners, they regulate people who pump groundwater.
the people that are pumping? Does somebody have a name, address and stuff? Oh, they know.
With the exception of the city of Brackettville, every person who pumps more than, other than domestic livestock use, has a permit from the district. If you want to get a list of every permit, you can.
Because, we're not getting any information from how much money that somebody's getting, because where are you from?
Ma'am. We're gonna go ahead.
We have to move on. We'll be here all night.
If you have some questions, just give it to our general manager and we'll try to answer them for you.
I appreciate y'all's indulgence, I appreciate your time. Board members, do y'all have any questions?
The rules that we, on some of these, we don't have a choice. We have to adopt this by December 1st. Is that correct?
This petition rule, specifically the one dealing with petition for rulemaking, I think is the last one on the list there. A rule allowing for the petitions has to be adopted by December 1st. Now technically, you could, that first sentence, if all you wanted to adopt is that first sentence, you could do this. Yeah. You've met that deadline. You can file a petition, but I think you want to have some standards for what you want in those petitions.
But your recommendation is pretty much adopt these as you have outlined.
Yes, sir. The big question mark is, do you want to require a number of signatures?
Can you all please quiet down? So we can hear the questions. Sorry. Can someone call order? I'm having trouble hearing the conversation.
We were talking about these rules that the state mandated that we adopt, and I was asking, when we need to do that. He clarified that, the majority of these, we have to do it, we have till December 1st. So we will announce that probably, if you said 20-day public comment, we'll probably announce that at the October meeting, discuss it in November and adopt stuff at that time. I would guess with the 20-day requirement, because there's not 20 days between now and our October meeting. That's what the discussion was there. It's whether the state requires it, and they do.
Well, wasn't there just one that you had to have in place by December?
Yes, the petition for rulemaking is the only one required to be adopted, the rule has to be adopted by December 1st. I told him the example, the first line, a person with a real property interest in groundwater in the district may file a petition with the district to request the adoption of the rule. If all they want to do is adopt that, they can't. That met the deadline. I think they want to set some standards, what has to be included in those petitions, and that's what the rest of that rule is. Those are all my recommendations. They can say whatever they want to say. You have to bring in your firstborn child, whatever they want to have, whatever they want to put in.
I'm gonna move to item number 8, which is gonna be the discussion and possible action. Call for the public hearing to amend the district rule. Implement,
Since you only got this, like today, if you want to table that till to the October board meeting, I think that might be a good idea. Give the board some time to digest all of these.
yes, sir.
If you have questions in the meantime, just call me. I'll be happy to answer anything I can.
Yes,
Make a
sir.
motion to table.
I have a motion on the floor. Table. Second. Any further discussion on that?
Matt, who made it?
Blake
Okay.
made the motion. Mr. Shaw made the second. Any further discussion on the item? All those in favor?
Aye.
So moved. All right, we're gonna move to the next item on the agenda. It's gonna be, Dr. Hutchinson. We're gonna have your presentation.
Thank you very much for the opportunity to make this presentation. Before we get started, groundwater impacts Lost Forest Springs. I have no idea how this rumor started. This is supported by the data. If you remember, from the last year and a half, from July, a little over a year, July of 22 to May of 23, the work I've been doing and the presentations I have made have been focused on trying to quantify those impacts. So the issue is, it's a non-issue. A very different question came up in July of 22 when the spring first went dry. If all the pumping stopped, would the spring return? And the answer was maybe a little bit. It certainly wouldn't come back to the full average flow. You need rainfall to do that. And we saw that in August. When it started to rain again, the spring came back. So through this presentation, I'm going to present data that will provide estimates of the recent pumping estimates and how this all fits together. Now, starting in July of 22, I'll remind everybody of the schedule we were on. It was an 18-month schedule that started off with updating the management plan. We went through that process with a committee through the fall. That plan was adopted in January. In May, I presented the first part of the preliminary part of the groundwater model I was working on that was being developed. And then this last part of the year was devoted to how we're going to incorporate that information into updated rules. So tonight, there's some question about my credentials. So I'm going to go through that. I'm going to review the comments from the meeting 2 weeks ago. I took notes, I watched the video, I took notes, and I've classified them into 4 different themes. And so the presentation is organized around those 4 themes to answer the questions that were raised 2 weeks ago. Then I'll go through some recommendations on what rules, on how the rules should be adopted or modified to deal with all this. And I know that there's a lot of slides here and there's a lot of detail. We're not going to be able to get through it in a lot of, it can't be digested tonight. And so this presentation will be posted on the website. Folks can review it. They can reference it. And I put links to references I use and data that I used In fact, the website already has an area down. The second download is a link to all the memos, tech memos I've been preparing for the groundwater model. So basically, this is a kind of a brief history of my education, the licenses I hold. I'm not going to belabor too much of this. I've worked in California and Arizona from 83 to 01, and then from 01 to now in Texas, starting at El Paso. Even though I was born here, I got taken away. Since 2012, I've been an independent consultant, and I now live in Brenham, Texas. These are some of the places I've worked and some of the things I've done, and the key things down at the bottom. I know Greg just mentioned a couple of them: the Middle Pecos Groundwater Conservation District, Lost Pines. I've been working in Kinney since 13. I've been dealing with GMA since 2009 on developing DFCs throughout the state. I was one of the expert witnesses for the state of Texas in the Texas-New Mexico litigation. So I've done a few things. In terms of GCD, I've been involved with rules development, management plans, permit reviews, expert testimony. Greg mentioned the LCRA case. I was the district's expert witness on that. I've done a lot of things in a lot of areas for 40 years. I've developed a lot of groundwater models. I've run a lot of groundwater models. I've published, given a lot of papers. So anybody has any questions about that, I'm happy to talk about that, but I don't want to waste a lot of time going through all these various things. Now, one of the things that happened 2 weeks ago was the summary or survey questions the results of the survey were distributed to the board. There were 7 questions. And so here's a summary of what those were. And in this presentation, I'm going to specifically cover 5 of them. I'm not going to deal with access to property, and I'm not going to deal with meters, but I'm going to cover all the other elements. So I took notes. These are kind of scattered because I just did them chronologically as I watched the video. In terms of pumping and data meters, triggers, cutbacks, how other districts do things. There was a discussion on what Chapter 36, the authority and responsibilities of this board were. The DFC hasn't been met. More permit stuff. 2 CFS in the flows in the spring is not acceptable. Is there a drought? Where's the data? We need action to curtail pumping. The district's had 20 years to address this, on and on and on. All of those fit into one of 4 categories except the last one. The last one brought up Los Angeles and what they did with the Owens Valley. Now, I'm not going to belabor this, but I was involved in all that. It's a very good example of how you balance, and Greg talked about this, how you balance water supply and environmental protection. It's different there than it is here, but it is an example that is all through the West and how you deal with water problems. So anybody who wants to ask me about this, I'm happy to talk about it. I worked on it a long time. Okay, so all those comments I break down into these 4 areas. Responsibilities and authority of the district relative to Chapter 36, the desired future conditions or DFCs, the state of the aquifer, and kind of umbrella term on that, and then specifically pumping and permits. So the comments at the meeting focused entirely on the responsibility and authority of the district related to conservation and pumping restrictions. I kind of color code these things: green for what I would classify as environmental things, and blue for water supply things. There's another part of the code that allows the district to preserve historic and existing use consistent with the management plan. In fact, the management plans of this district since 2004 have recognized making a balance between the green part, the conservation, preservation, efficient and beneficial use, and the supply part, protection of private property rights. This language has appeared in every management plan since 2004. This balance between property rights, and in this case, that's the existing historic users, and the conservation and preservation of groundwater is a fundamental choice that guides the management plan and the rules. Early in the district's history, there was a policy decision to issue those permits. Not every district issues those kind of permits. They were issued here. And in 2010, they adopted the first desired future condition that protected historic Los Moras flow. The DFC reflects, we'll get into this, what it does. Let's talk about the DFC. Now, before a DFC can be adopted or even proposed, the districts are required to look at 9 factors. And they're all listed here. And they must provide a balance between the highest practicable use and the conservation, preservation, protection, recharging, and prevention of waste. And the 9 factors include, in the green category, aquifer conditions, other environmental impacts. To go to your question earlier, this is where environmental impacts fit in on a DFC level. The blue, the water supply needs and the property rights, those have to be considered also. These are the DFCs. In GMA, Kinney County is in 2 GMAs. In GMA 7, it's Los Moras spring flow. In GMA 10, it's a threshold water level in what we know as the Tularosa level. Now, these DFCs were originally adopted in 2010. That was the first round of joint plans. They're updated every 5 years. So they were also adopted in 2016 and 2021. They were based on a model that was developed in 2010. This model ran on annual time steps. That means everything that happens, the results come out on December 31st of each year. So there's a limitation that the model results only look at end of year conditions. This model was then used by the Water Development Board under the statute to calculate the MAG, or the modeled available groundwater. Now, I want to emphasize this point because it explains a lot of the history. In 2010, during the first round of joint planning, where DFCs were developed, districts were required to permit to the MAG, or the model available groundwater. That is not in the statute anymore. That was taken out in 2011. The MAG is simply the amount of groundwater pumping that will achieve the DFC. It is one factor in permitting. The statute has a long list, and then the rules have a list. MAGs are one of the factors. And we've heard about water marketers and exporters. They often incorrectly use this MAG as a way to identify areas that are of interest to them as far as their proposed projects. Districts are required to manage to the DFC. These are 4 examples in the water code that talk about that. It actually deals with failure to achieve the DFC. They can be, petitioned or sued or whatever. It recognizes that models are imperfect. DFCs and MAGs are linked by a model. So you want to pick one, you pick the DFC. That's data. You always want to use data to make management decisions and evaluate consistency with the DFC. Now, the model that was developed in 2010 was based on data that was provided by the district. It was done by the Water Development Board. The data that were provided were not the actual annual pumping amounts. They didn't have any permit or meters or information on that. They provided permitted pumping amounts. The total historic and existing use permits total 63,000 acre feet. That was the basis for everything. That's why the MAGs are as high as they are. They're at 76,000. And there is a fundamental disconnect between protecting that historic spring flow, the DFC, and the MAGs. If the MAGs were pumped, the spring is gone. In 2013, when I got hired to work for the district, it was recognized, I pointed out this MAG permit total DFC issue. And the focus was on getting data to improve the model, to revise the DFC. That was our major focus. So as part of that, we instrumented many wells. We're now up to over 63 wells in the monitoring network. Put in rainfall gauges. In 22, when the spring first went dry, I developed an empirical model of spring flow, rainfall, and pumping. Again, pumping has an effect on spring flow. You couldn't do this if that was not the case. We did satellite analysis of irrigation. It was a quality control check on the permit reports. Issues were raised about the permit reports. The satellite work was done in part, and we'll get more into this later, in part to provide a check on those. In 23, we're updating the groundwater model. It's almost completed. And that will replace the model that was the 2010 model, so we can do better on the DFCs next time that reflect things more appropriately. And Jim will talk about this, the app that will be used to report permit pumping, so we don't run into these problems that we've had with the permit reports in the past. So here's a bundle of questions that came up 2 weeks ago related to Los Moras Spring flow DFC. And it's all, basically the upshot of it was we're not meeting the DFC. Well, we are. Let's look at the data of the spring. And let's also review section 5.8 of the management plan that was just adopted in January. All the answers are in there. So the issues of not being able to meet the DFC, waving the management plan around, read the management plan, it's in there. And we'll go through that. These are the daily data going back to 1940 in the spring. We can see it goes up and it goes down, it goes up and it goes down. And you see there at the bottom, it does and has dried up in the past. Zero flow. It's also been very low for long periods of time. It's also been very high for periods of time. Note though, in the 50s during the big drought, it was very, very low, but it did not go dry.
Can I ask a quick question about the West Dock?
We'll probably get to it in a minute.
It's an old gauge.
Huh?
It's an old gauge. Correct?
Well, yeah. The old gauge was from 40 to 2014, and then in October of 2014 we have the new gauge. And we've got that right here. The old gauge did not cease flowing during the 1950s drought. It did go dry 12 times by end of month data. It was basically below 1 CFS 8 other times. There's a list of the years. And in 2014, the new gauge was put in, had no flow in the summer of 22 and this summer. Now these slides came directly out of the October 13th, 2022 Management Committee meeting. It explains how these data are used in understanding where we are with respect to the DFC. It's an end of year flow, not an average of all years, not an average of any one year. In 2013 and 2018, we had a similar thing. We had a graph like this that showed how we were either in or out of compliance. The new gauge has 7 years of end of year data, so we extended that with the empirical model. And we plot up precipitation, rainfall, versus spring flow. As more rain occurs, there's more spring flow. And we put those are the years. We put bounds on that. And then we see, okay, how are we doing since 2014 with the new data, the new gauge? Well, they all fit within the bounds. There's one a little bit low, one a little bit high, but they're all basically within. And that strips out the existing data. And then in 2022, in May, that was associated with the last time we had a big meeting, there was a letter, there was an agenda item that looked at this, because as it's described in the management plan, this comparison is made with annual precipitation data from Quad 807, and those data are not available until around April of the following year. And we want to use official data from the USGS, not provisional data. So it all came together in April. We did the comparison, and it plots up right near the 2020 point. This comes right out of the board meeting packet. Okay, so anticipating some confusion or criticism in this, that this is somehow unique or contrived. This is an example of indexed compliance. This was the basis of the settlement of the Texas-New Mexico lawsuit. Basically, in 2013, Texas alleged that groundwater pumping in New Mexico was capturing water that should have gone to Texas under the 1938 Rio Grande Compact. The settlement was based on an index flow and a gauge at El Paso. In other words, when it's dry, Texas gets less water than when it's wet. It's indexed by, in this case, reservoir release. In our case, it's based on rainfall. It's a very common water resources administration technique. Now let's talk about the state of the aquifer. We've had a lot of comments about that. Drought or no drought, where's the data? Las Moras hasn't been flowing, the aquifer is in trouble, area is becoming more arid. Well, in terms of the data, back in June, I put out a tech memo that looked at all the precipitation and spring flow data because I needed to develop management objectives and thresholds for simulations. So I wanted to base those on data. And that memo's, on the Google Drive, anybody can look at it. This is one of the plots. It looks very similar to something Will did. But this starts in 2015. The bottom of it is the monthly rainfall. The top is the end of the month spring flow. Well, you can see that every time there's a big spike in rainfall, the spring goes up. When there's periods of low rainfall, the spring declines. And we're in a very low period right now. But we haven't had much rain lately. So you can characterize aquifer conditions based on Las Moras spring flow. Well, it's the natural outflow of the aquifer. So when you have a flowing spring, that suggests fairly full conditions because it's basically rising high enough to leave and go and become surface flow. We can also characterize it with the groundwater monitoring network that we put together. We've added the zones 1, 2, and 3 depending on how they're correlated with spring flow. So when the spring stops flowing, all that means is the groundwater levels that in those wells, we can see how far down it is to understand how much recovery is needed in order to restore the spring flow. So if you haven't read Bennett and Sayer, the 1962 report, it's still probably the best comprehensive hydrogeology of Kinney County that exists. I've got a link to how you can download it. And they have this very nice diagram, conceptual diagram of Las Moras Spring. So we're talking about the Edwards Aquifer, domestic aquifer, and through faulting and solution channels, there's a direct connection from the aquifer up to the surface of the land. Now this aquifer is under pressure because there's a confining layer, the Grayson Shale, that confines the upward movement of water. So there's pressure building up in the aquifer that causes the water levels to rise up to above land surface. When those water levels or pressure levels are above land surface, you get water flowing out of the spring. When the water levels are lowered through drought, pumping, whatever, it's still under pressure, but it's just not above land surface and you get no spring flow. But it's still very close to the surface. Now we can see this in the Dooley well. The Dooley well is a great resource for this county because it's got a 10-foot standpipe. So when the water level comes up above ground surface, it's not a flowing well, it's still in the well because the casing goes all the way out. Now, this is a graph that Jim produces every month for the board. This is based on the instruments that we put in back in 2013. We can see over here, this is the ground surface, 0. This is the top of the standpipe. So when the water level is back in 19, they got above the standpipe. You can't get above the standpipe. That's just when it started overflowing. But we can see that back in 14 and 15, water levels were down 25, almost 30 feet. Right before the rains last year, it was down about 23 feet. Right now, it's down about 10 feet. So the water levels aren't nearly as low as they were even last summer. They're only 10 feet below the ground surface, so when we do get rains, hopefully this fall, water levels will rise back up, spring will start flowing again. And we know that the spring and the Dooley well are correlated. So why is that water under pressure? That's for recharge. Recharge of the Edwards Aquifer outcrop north of the spring. Annual recharge varies with the rainfall. I have a tech memo on that. There's a link for it. Basically, this is how we conceptualize the recharge. The spring's down here. I should have put it on the map, I'm sorry. The red is the Edwards Aquifer outcrop. The blue lines are the drainage channels within that. Most of the recharge is going to occur in those channels. A little bit will happen in the upland areas, so there's a differentiation there. The blue, that's the outcrop of the Trinity. The orange, that's the outcrop of the Austin Chalk. That's what sits over the top of the skier, and below it, that red, that Edwards Aquifer is down underneath that. The average annual rainfall in the area from 95 to 21 was 11 to 41 inches. That's about 22 inches a year. The total recharge area is about 700,000 acres. So based on those calculations, and these are consistent with what was embedded in Sayre, it's about 79,000 acre feet of recharge every year. Now it ranges from about 28,000 to about 150,000, just depending on where the rainfall is. That average rainfall represents about 106, that average recharge represents about 106 CFS, or about 1.3 inches. So that 1.3 inches divided by the 22 inches, that's about 5.8% of the rainfall. 5%, 6%, that's characteristic of a karst aquifer. If you were in a sand and gravel aquifer, maybe 1%. So you have an aquifer here. This terrain is right to take rainfall and send it underground, have springs, but the cost is the water levels go up and down all the time. You know, sand and gravel aquifer, things are a lot more muted. Here you get big recharge, but big drawdowns later on because the water's moving. And where's it moving? Here's the surrounding areas. Kinney County's down here in the lower left. These are the 2020, these are the most recent estimates that the Water Development Board has of groundwater pumping estimates out of the Edwards and the Trinity formations. You can see Kinney County's about 5,200. Just north of us, it's on the 800 to 551 range, but in Uvalde County, it's 57,000. Now this is kind of cartoony, but this is basically the way groundwater flows. It's coming down from Edwards County into Kinney. Some of that kind of moves over into Uvalde, and then it's all heading towards Medina and all towards San Antonio. So you can see that the water that falls in north of Kinney County and in Kinney County is on the move. Some of it squirts out with the spring, some of it's pumped by farmers. A lot of it moves out on its way out. And you can see next door, 57,000 acre feet of pumping, that will have an effect on drawing more water in to their area. Excuse me. There was a comment by Director Ward that the area is becoming more arid. Data suggests that aridity is increasing. And I did this analysis as part of irrigation demands analysis. We start with precipitation and evaporation data. That's fundamental to any agronomy calculations on how much irrigation is needed. And then pumping can be calculated by understanding those, taking those needs and multiplying it by the irrigated acres. We also supplemented that with the irrigated acreage came from the 22 satellite analysis. And that's all in the management plan. So here's the pumping. I only go take this back to 1954 because the evaporation data only goes back to 1954. Rainfall data go back to 1940, but we're only going to deal with 54 on. So here's the rainfall. We can see the bad drought in the 50s. We can see the drought we're in now. And we see there's a slight decline over time, over this period, which suggests that on average, rainfall is decreasing in the county or in the area. Now, if you remember back in July, I showed this. That red line represents the actual data, the 10-year running average of the actual data. The black line represents a tree ring data set. A 10-year running average of the tree ring data set that goes back to the 1600s. You can see the red line matches up nicely with the black line, so we're on solid ground there. But we can also see that that black thing bounces up and down, but it has a bit of a decline too. So this increased aridity is nothing recent. This has been going on since the 1700s, based on the tree ring data. Evaporation is the other component of irrigation needs. These are the evaporation data, the annual evaporation data, and it's going up, and it's really spiked up in the last couple of years. It's been hot the last couple of summers. So when you put all that together, these are the irrigation needs expressed in feet per year. They're going up. So even if you have the same acreage, more irrigation water is going to be required. The irrigated acres, we did that work in 22. There was questions about the reliability of the permit reports because there was self-reporting. So we did the satellite work to achieve two goals. One was provide a quality control check on the permit reports, and the other was to extend the record. The permit reports only go back to 07. The satellite work took us back to 95, so we have more data, more time period to run the model, to calibrate the model. So I was very surprised to hear criticism that I was using the satellite work. That's how I was responding to a comment. There's correlation between the groundwater level monitoring and the spring flow, and that yielded zones, potential management zones. 1, 2, and 3, strong correlation, moderate correlation, and weak correlation. That's all covered in the management plan. These are the zones, the preliminary zones that we developed based on that correlation work. These are the irrigated acreage estimates based on that work from 95 to 22. Note there's a few years where it really spikes up in zone 3. That's the area way to the south that has no influence on the spring. But we don't see any long-term trend. Now, so we're really interested in zones 1 and 2. Oh, I'm sorry. This is the permit reports of the pumping from 07 to 22, only in zones 1 and 2. There really isn't any permanent pumping in zone 3.
Yeah.
We see a spike at the end, and we'll talk about that.
There are pumping reports starting in 2003.
I don't have them.
Well, I handed the board the chart that was on the wall. They could share it with you possibly.
Okay, so zones 1 and 2 are the ones that are of interest for spring flow management. These are the irrigated acres, and I treat them both the same for purposes of this graph. We see, if not a steady amount on average, a slight decline. Now the groundwater pumping, the black line represents the estimates based on this calculation needs. The blue dots represent the permit reports. Most of them fit reasonably well, there's a few outliers. Fairly flat, maybe a little bit of a rise, but certainly a big spike in the last couple of years. We are currently in drought conditions. I don't know why there was an argument about that 2 weeks ago. Aridity in the area is increasing. It has been since the late 1600s. Irrigation acreage varies year to year. Total groundwater pumping for irrigation is increasing, but at least in the last couple of years, I think it's more due to the aridity than irrigated acreage. Reports of the permitted pumping are generally consistent with the estimated pumping calculated from the precip and evaporation data. It's better in drought periods than wet periods, and we're going to fix that with the monthly reporting of pumping through the app.
Excuse me, I'm so sorry to interrupt, but wouldn't the evaporation, possibly be due to watering at the wrong times of day, which we have seen?
This data,
It's beyond that.
the evaporation data is for everywhere, not just the irrigated fields. This is evaporation data maintained through meteorological stations by the water, and it's reported by the Water Development Board. What you're asking is a totally different question.
Well, I don't care if it's DMV or BLJ or something like that.
Ma'am,
Yes.
no,
Yeah,
no comments until he finishes. We said that a while ago, so you'll get your chance.
I missed that, thank you.
All right, thank you.
So the data analyses, I think, address the concerns raised at the meeting 2 weeks ago. And they provide a foundation for evaluating model simulation results. Now I'm going to compare 2022 with 3 different cases. 2011 and 12, that was a bad drought. 1950s, that was a terrible drought. And 13 and 14, drought wasn't as bad, but as the analysis showed, there was more irrigated acreage than there is currently. So here's the rainfall comparison of 2009 to 2012. This is characteristic important because 11 was really bad, 11 inches. It was preceded by a near average year, and followed by a not so great year. 19 to 22, it's just been bad for 4 years. The sums are fairly close to each other. But when you look at the pumping and the summer-spring flow, you get 2 different things. In 11 and 12, the pumping was between 4,500 and 5,000 acre feet a year, and the spring was trickling out about 2 to 6 CFS. In 21 and 22, pumping was about 7,000 when the spring flow was at 4 to 10, but then it was at 9,600 acre feet of pumping, spring was dry. So that tells me that if the pumping had been, in 21 and 22, if the pumping had been more like 4,500 or 5,000 the way it was in 11 or 12, you'd probably get around 2 to 6 CFS of flow. In the 1950s, Los Moras never went dry, but it was low, 3 to 8 CFS. So that, using that same approach, if the 21 and 22 pumping, that amount above the 1950s pumping resulted in about 3 to 8 CFS flow reduction. Well, Bennett and Sayer did their study in 62. They estimated about 4,000 acre feet of use, groundwater use, in 1955 and 56. They said that was about 2,000 acre feet of pumping and 2,000 acre feet of flowing wells. So we got that one single data point. In 13 and 14, the rainfall was higher than 22. The spring flow was between 1 and 5 CFS, but the irrigated acreage is about the same, but the pumping needs in 22 were much higher because of the aridity. So that tells me that if the pumping had been decrease, despite the aridity, back to the 4,500 to 5,500, you might have got 1 to 5 CFS of flow. So to bring all those three together, we're looking at 1 to 5, 3 to 8, 2 to 6, some number like that. Call it 5 CFS. That's the data analysis. So that's important because then the model, using a similar kind of simulation, should give you about a 5 CFS increase in spring flow. If it gives you none, the model's wrong, or is that a real problem? If it gives you 15, that also suggests a problem. So the simulations give us more flexibility and robust analysis of that connection between the pumping and the spring flow. We can simulate the repeat of the 50s drought. We can simulate things all the way back to the 1700s if we were that interested. We can isolate and simulate the effects of the increased aridity. And most importantly, these data are a lot of averages and a lot of stuff. The model gives us a much better handle on the spatial variability of rainfall and pumping, because that has a big effect. Wes Robinson and I talk about that all the time. So these models are useful to quantify the impacts of pumping and estimate the increase in spring flow if the pumping were to be reduced. Models are best used to guide data collection and when comparing different alternatives. They're not reality, but they're good tools to compare different things. And like I said, they need to be consistent with the data analysis. Now, Will sent an email out last week and wanted to know how much impact all the combined pumping has on spring flow, and specifically requested a scenario with all the permitted wells and all the zones shut off to see what the impact would be on the spring flow. Well, I answered that question in May. Item 2B from the workshop in May. There was a simulation of increased and decreased pumping, overall pumping, pumping by group, that sort of thing. These are sensitivity analyses just to sort of make sure the model is responding correctly, that when I turn pumping up, spring flow goes down. When I turn pumping down, spring flow goes up. I want to make sure everything is working correctly. These are distinct from management simulations. The management simulations were covered in item 2D, slide 12. This is where we have a specific trigger and a management action that we're simulating. The focus of these management simulations is because in the management plan that's been in place since 2008, there's a provision to manage production without unduly increasing the frequency of the natural cycles of springs and intermittent streams going dry. This language has always been there. The tech memo I did in June was based on the historic analysis of precipitation and spring flow. And it outlines 9 scenarios that I want to run that look at different thresholds based on the analysis of the data of spring flow and different management actions that could be taken to see what would happen. So in summary, there's 9 here. The first one would be when Los Moras hits 4 CFS, you cut 25% of the pumping. All the way down to when Los Moras hits 15 CFS, you cut 75% of the pumping. The idea there is to see what will happen in the spring if you took these actions. So what would the board do with this information? Well, when I look at it, you got 4 basic options. You can set up a drought plan that essentially adopts one of those scenarios. You could also use the results to look at something in between, higher reduction, lower reduction, something in between. You could revise the simulation to not use the spring, but to use the Dooley well, for example, as the threshold. Or you could conclude that the spring flow recovery, which based on the data analysis looks like it might be about 5 CFS, would not be sufficient to warrant that level of reduction. So these management simulations provide insight related to something the board can do. That's way different than a sensitivity analysis to shut off all the pumping. 2 weeks ago, there was a lot of stuff about the drought contingency plan, need to curtail pumping, other districts curtail pumping, but there's a lot of complexities given the circumstances here relative to the way the permits are and what the actual pumping has been, and the way the pumping varies year to year. Now we're going to step back a second, because this notion that all other districts curtail pumping is not exactly true. The Lone Star Groundwater Conservation District in Montgomery County, north of Houston, which is mostly municipal suburban type water uses, recently adopted a temporary drought buffer. When it started, it was 10%, now it's 15%. They basically say, whatever your permit is, go 10% over. Now it's 15% over. Retroactive to January 1st. You have to pay the fees, but you can go over your permit. This is an example of how a district applies a policy decision that's different in this concept of balancing production and environmental protection. And as Greg mentioned, the environmental protection here revolves around subsidence. So let's talk about this complexity with the pumping and the permits. There are 47 historic and existing use permits. This is what we talked about at the beginning. The board back in 2003 decided to issue these under the authority of Chapter 36. Each permit has between 1 and 22 wells, in total 144 wells. Permits, it literally is there's a permit for 0.66 acre feet a year, all the way up to 9,500. Now these permits have both, a lot of them have both a historic amount and an existing amount. It's a little confusing. At the time these were developed, the historic period was 1960 to 1991. The existing period was 92 to 03. So folks sent their information in, they went through the process, and essentially the permit limit is the higher of the two. Some have existing, no historic. Some have historic, no existing. Whatever the higher is, that's your permit limit. Some have both. So let's look at that. This is how it breaks down by the management zones that are in the management plan. There's 55 wells in zone 1. That's the one that's most closely associated with spring flow. The permit limit's 35,000. In 22, 2,500 acre feet were pumped. In zone 2, there's 88 wells. The permit limit's a little lower, 27,000, but the pumping was higher, it was 3,400. In zone 3, there's 1 well, limited 250, it's never been pumped. These are the number of wells associated with each permit. I don't put the actual permit number, this is just an informal ID to show the list. And you can see the one with 22 wells, most of them are 5 wells or less. This is the permit production limit. Again, the higher of the existing or the historic. There's 2 that are over 9,000. Most of them are less than 2,000. This is the pumping reported from those wells. We saw the spike go up from the report, matches up with the calculator. That black line is the same one as this, but now I've plotted it with the permit limit, the 63,000. So this represents that same black line, but now that's the percent of the permit limit. Even at the highest pumping last year, it was about 15% of the pumping, or 15% of the permit limit. Okay, so each permit is supposed to report each year. So we have 07 to 22, we got 16 years. I'm interested in this analysis, what is the highest that ever was pumped in any one year? And I take that value and I plot it up, and you can see that the highest value in 3 of the permits was about 2,000 acre feet. Some haven't pumped at all. So I call that the maximum reported annual production in any one year. What year did that happen? Well, 10 of them happened last year, but a whole bunch of them happened in 08 and 09. Let's put this pumping into some perspective. Let's do it in CFS because that's spring flow. The permit limit totals are 87 CFS. The sum of those individual maximum numbers is 26 CFS. 22 pumping was 13 CFS. 2011 pumping was 6 CFS. But remember, the spring averages 24 CFS. The recharge averages 106 CFS. So we're dealing with a fairly small component of the water budget in terms of the recent pumping. But it is significant with respect to the permit limits. Okay, now this is the maximum annual production as a percentage of the permit limit. These should all be under 100%, but they're not. Some of them have gone over. This shows all the ones that go down or under their limit. You can hardly see above that line because they're fairly small in comparison. So I just pull out the 7 that have gone over. The highest is 121 acre feet. Now, from a spring flow standpoint, I don't think this is significant. From an administration standpoint, having several of these over 10%, that is a problem. So just quick numbers, using 16 years, 47 existing historic permits. There have been 12 instances of overpumping and 7 permits. The worst, like I said, was 121 acre feet. One was up to 40% over their permit limit. Overpumping events represents 1.6% of all the results, and 15% of the permits have had at least one overpumping problem. This is good information. We knew there were problems. This is what the app's all about. So there's 7 permits that have never reported any pumping. That's about 15%. They went to a lot of trouble to get their existing historic use permits. They never pumped. That's 43 wells. One of the permits reports in round numbers, 500, 1,000. Everything else looks like a meter reading. That suggests to me it could be an estimate, not a meter reading. That needs to be dealt with. Now the 2 highest permits, one is never pumped, one is only pumped about 1,100 when the permit's at 9,600. So of the permits with actual production, that's 40 of them. 10 had, we saw that one graph, 10 had their maximum pumping in 2022. That's a quarter of all the permits. But 45% had their maximum production prior to 2014. So let's talk about how to deal with this, review the permit totals and reset the totals. There's a lot of comments about that. And it was one of the subjects of the survey results, that question 6. So if you sum up all the maximum productions from each of those years, from 07 to 22, you get about 19,000 acre feet a year. If you did it from 07 to 17, you get about 11. If you did under the Q6, the last 5 years, you get about 12,700. But they wanted to put it at 150% of that. Well, that turns back into 19,000 instead of 63. So what does that mean? Well, if you have the permit limit and you think the concern here is that eventually you would actually pump the full permit limit, the analysis shows that that is inconsistent with the goal of having some minimal spring flow during a drought. Pumping to achieve that goal appears to be in the neighborhood of 4,000 to 5,000 acre feet a year, which would be a 50% reduction in the pumping last year, or a 75% cut from the survey request of 150% of the highest in the last 5 years. So this highlights the difficulty in curtailing pumping because curtail it from what baseline? We've seen the pumping varies quite a bit, irrigated acreage varies quite a bit. It's not a big stable system. It makes it very challenging. Now this, so I don't get misquoted, I'm not saying this should be done. I'm saying if the goal is to have some minimal spring flow, like 1 to 8 CFS, this is a policy decision of the board that requires balancing that objective with the property rights associated with the historic and existing users and permits. So do not misunderstand. I am simply trying to point out what the data show if the board were to move in this direction, but that's a decision that y'all have to make. So let's go through the rules. As you see, the MAG is not consistent with the DFC. Now, MAGs are one factor in the permit. Somehow, Greg will come up with the language, I'm sure, that acknowledges in the rules that the MAG is not a reliable number, and we're trying to avoid having a problem where it's used as an argument to issue a permit. That, oh, you've got this big MAG, you should issue a permit. No, the DFC is the important thing. We know the MAG's wrong, at least for now, until we can fix it in 26. We do need to update the DFC and then the MAG and the next round of joint planning. That's not a rule, but we do need to do it. And you need to make a decision on whether you want to continue to use lots more spring flow or convert GMA 7 into a threshold in a well like we have at GMA 10. We can have that discussion later, but that's on the table. We do need to revise the permitting process. We need to streamline it. This testing period stuff is not needed. We also need to recognize those small production that has no effect on the spring should have a simple approval process. A large permit needs to have an evaluation on how that would affect Moras spring flow and the DFC. And there's options there to require the applicant to do that investigation or the district to do it or review it and analyze it. I mean, there's all kinds of ways we can approach that. And we need to discuss how you define large and small. We need to increase the permit pumping reports to monthly using the app that Jim's going to talk about here in a little bit. And we need to add requirements related to the district staff for deadlines for processing and reporting the data. That's been a big problem in getting this work done. Now I know you have an agenda item for a field tech. That person should develop a schedule to audit the meter readings. I think a 3-tiered priority system, wells that have a high priority or potential for impact, audit them 1 or 2 times a month. Ones that are kind of medium, maybe 3 to 5 times a year. At low priority, maybe 1 or 2 times a year. Do an audit of the reports by going out in the field and reading the meter. There also needs to be a process put in place for the field tech to report over pumping to the board for further enforcement action. And post the monthly zone totals data on the website. Now this trigger and threshold thing, we can develop the specifics if you want to move in that direction as a policy thing. If you're not inclined to, we can stop it. And that's entirely up to you, given that what we're seeing here. So do y'all have any questions?
I've got some, I'll give you later on.
Okay.
No, that's a question. How much longer do you?
That's it.
Yeah, we're gonna go ahead and do the next item on the agenda.
I think Matt, I think it would be helpful to do here. I think that it's part of open meetings act that you are allowed to ask questions just with every agenda item. Not trying to be a pain, just think it's helpful since it's fresh.
I'm gonna wait till we get finished with the next presentation before y'all answer any questions. So, just hang on a second.
I'd like to hear what the others.
All right, I'm gonna move on to the first two. What's the bathroom?
Are we required to have open comments after everybody's?
Yeah. Aren't we allowed to comment? Don't do that. Yes, I have. Public comment at the beginning of the meeting or before each agenda item is the informational ones, don't require any public comment.
Yeah, I need to take my break there. I wasn't expecting 3 hours.
I don't know if talk
Yes, sir.
Ladies and gentlemen, thank you very much. Appreciate you having me here tonight. I will try to make this as fast as possible. I realize that it's late. My name is Jim Burton, work with the Groundwater District, and I was asked to, like Dr. Bill, asked to give a little bit of background about myself, how we got here. Got a degree in civil engineering, specialty in water resources and hydrology from the University of California, Irvine in 1989. Was a groundwater manager for the Metropolitan Water District. It is the largest supplier of treated water in the country. From 91 to 2001, monitoring the potential impacts of the regional water table drawdown for construction from pumping hundreds of springs, streams, special vegetation status species for both public U.S. Forest Service property, privately held lands, including tribal lands. And I'm going to talk a little bit about my background because I think there appears to be a misconception that somehow the Groundwater District is not trying to balance the environment, both of the environmental concerns and the property right concerns. And my background of 30 years in doing this business is exactly that, trying to find a solution where we can come together and realize what is the way that you can try to do this. I went to work for Somas in 2001. I was a vice president. I managed their natural resource group. I think at the time we had 28 offices in 6 states, evaluating impacts of hydrologic and biologic resources from various sources, pumping, recharge roads, land development. And our tagline was balancing the natural and built environment. In 2009, I'm the president and CEO of EcoKai Environmental. Technically, according to my paycheck, I'm a principal water resource engineer, but my primary focus over the last 10 plus years has been focused on the development and implementation of water monitoring networks, specializing in instrumentation, telemetry. Currently, most of our work right now is in Texas and California. I've worked in Arizona, Hawaii, state of Washington. I've got sites right now that I can log in and look at in Costa Rica. We've done international work. And again, have installed hundreds of monitoring instruments, groundwater, surface water networks in Texas. I was intricately involved with Dr. Hutchinson when GCD, when Valverde was looking at possibility of becoming a groundwater conservation district. In 2012, 2013, we collected data,
worked with Dr. Bill, developed the groundwater model. It went to Texas State Legislature at some point, but at some point, Alberta decided not to become a groundwater district. Currently working along with Mr. Ellis and Dr. Hutchinson with Middle Pecos Groundwater Conservation District. I've got instruments in Comanche Springs, all of the Belding and Williams Farms, all the legal side of it. We're the ones that are collecting the data. You can go onto their website, you can see the data, but that's our instrumentation. And then in Kinney County. So in Kinney County, I came here in 2013. Along with Dr. Hutchinson, we had just finished our Valverde work. And I'm not an attorney, so great, if I've got something wrong here, you can help me out. But I want to highlight a couple things because it really helped in the foundation of how we started to collect data. And if you haven't figured this out yet, I'm the guy, and my team are the folks boots on the ground, installing the instruments, collecting the data, providing it to Dr. Hutchinson, doing the analysis. Dr. Hutchinson and I have worked together for 30 years, a lot of different jobs. He's doing the analysis, making recommendations to the board. When we first started this, surface water, once it gets in the banks and channels of a river or it's in a lake, it's owned by the state of Texas. Groundwater is owned by the surface property owner. Groundwater, I don't want to get into all this, but groundwater rights, we go on. Since 2013, we have developed a monitoring network in Kinney County largely because of the cooperation of landowners in this county. And that I've got our monitoring network, except, Texas Parks and Wildlife, Texas DOT, maybe except for 2 or 3 wells that we are monitoring are on private land. There is a landowner that has allowed us access to their property. I have an instrument and a monitoring instrument inside of a well that is owned by that landowner, and the ranch managers. And I've got equipment that is mounted to infrastructure that belongs to them. The robustness of the network that we have now is largely in cooperation with the landowners that we've had in this county. And Ms. Hobbs, she has the relationships that she's had in this county. When we came here in 2013, we hit the ground running. She knew everybody, talked to people allowed us on the property. And so in the last 10 years, I'm going to get into the data collection and where we are. But I just want to lay the foundation that I'm extremely grateful that we're able to get out there and to develop the data collection that we've been able to get. And it's largely because of the ranch managers and landowners in the county. Monitoring network general background. For those of you that have been around and lived in the county for a while, if you all remember Dr. Joe Goebel, prior to 2013, Dr. Joe Goebel had volunteered for the district. He'd go out once a month. He would collect a water level measurement on a number of wells within the county. And it was some of his early work and his documentation of those monthly measurements that when we came in, we identified exactly what wells do we want to hit, what are the priorities when we want to begin collecting data. And so in 2013, we started collecting data. The direction from the board was to build a county-wide water monitoring network. And in the last 10 years, we've built a reliable, robust, highly accurate monitoring and data collection network. And right now we're collecting hourly data, depth and temperature. It's actually pressure, but we convert it to depth. Depth and temperature, hourly data. Data measurement or collection frequencies can be changed. You can change it to a minute if you wanted, but we've got hourly data, 60 plus active wells, 5 inactive for various reasons. I think Dr. Bill alluded to the 8 rain gauges that we've installed in Kinney County, particularly up in the northern part of the county where we're looking at some of the recharge. In the last few years, Texas Mesonet, Texas Water Development Board, Quad 807 data. Again, most sites are on privately held lands. 2018, we started adding telemetry into our monitoring network. And so right now, I think there's 20 or 24 automated sites that provide water level data, spatially distributed across the county. And it's about a third or 33% reported daily to a cloud platform. We've designed some things and had specific instruments manufactured for specific locations in the county simply because what you can buy off the shelf didn't work. Keep going. This is the Texomezanet. If y'all haven't seen this yet, this is a great, it's been funded by the Texas Water Development Board. I know Nathan did not, I don't think got funding this year, but the Texas Water Development Board. There's 8 stations in the county. The links at the bottom provides real-time or near real-time data for rainfall. This is our cloud platform, and if you look over on the right, I would normally never, this is HydroView in situ, but I would normally never plot all of this at once. But I've selected all at once just to go through and make it quick. But you can see the automated telemetry stuff started in 2018. Okay, depth of water. Depth of water graphs in the northeastern part of the county. The Bennett-Sayer, the 1940s original Bennett report, the 1962 Bennett-Sayer report. Again, as Dr. Hutchinson mentioned, very good geologic framework for the county. Everyone has identified the northern part of the county really provides Lost Moras Springs, which is a lot of why we're here today, as where the recharge is. And I want to go through and just walk through a couple graphs of depth of water and wells that we have up in that area to just show you what we have. Okay, so I think Dr. Hutchinson had a very similar graph. He had arrows. I borrowed this from Collins. This is a University of Texas at Austin graphic paper that was done. There's a source down there. But essentially, in the northeastern part of the county, groundwater is going to move 2 directions. Some of it's going to go towards Edwards and towards San Antonio, and the larger the hole is down in San Antonio, the more water that's going to go that way. Some of it's going to go down towards Lost Moras Springs, and there's flow paths that do both. Okay. So this is a map. This shows it's a very similar map, but I'm going to look at. So again, up in the northeast, I can tell you which wells these are. Okay, so this is a graph that, let me see if I can point this one out. So this is, you can see it's number 21 on the map there. I don't know if the writing's got a smaller page. Here's a graph. So this goes back to 2015. The y-axis up and down is depth of water. Depth of water starts at 180 feet, goes down to about 260. And as you move from 2015 to 2023, you can see the response to rainfall. You know, in 2016, we got some rain. It slowly comes down a little bit more. 2018, you get a lot of rain, kind of comes down. 2019, kind of comes down. And then from 2020 on, we've not seen the same response in this well from rainfall. Why? I'm not sure. This is not influenced. There's no pumping up in this area. This is right up in the northern part of the county. Direct recharge coming from Edwards and or rainfall directly up. This is a well that responds very rapidly to rain. Okay. This is another one in the very similar area up in the northern part of the county. From 2017 to 2023, you see the rain, you see the spikes in 18, you see the spikes in 19, and then it just flattens out. And we're not seeing, again, in this well, I can go on, I'm going to give you a few examples, but we can go on and on saying the same thing. Whatever's happening in the north, we've not seen the rainfall, and thus you're not seeing the recharge all the way down into the spring. Okay, this is one that's in the central part of the northern part of the county that has not recovered at all. Big spike in 18, a little bit more in 19, and then it just dropped. And in 2021, it went flat. We lost data because the water went below the pump, and water went below our transducer. They hired a well contractor, he went out, lowered the pump, and now, even though it's still about the same, it's about 321, 323, the production, it looks like they're pumping a lot because the water level is going down. The production, they used to be pumping maybe 30 to 50 gallons a minute, very small production for these folks up here. But you can see as the water level declined and went down, the hydraulic conductivity in the aquifer tightens up. Now they're pumping 5 or 10 gallons a minute, but the water's dropping 20 feet because the aquifer conditions up in this area are low. Same thing. Another well, similar location, spikes, it levels off. You don't see from 20, 21, 22, 23. Now, it doesn't mean that there hasn't been rainfall. You know, I listened to some of the meeting that happened a few weeks ago. We talked about rain. There was these comparisons. Well, what about this rainfall here? What about this rainfall here? What about the rain in 11 or in 1950? Conditions are different. what we're seeing here is regardless of whatever's been rainfall that's been falling, you're not seeing an aquifer response. If you don't see an aquifer response, you're not going to see flow in the spring. And this is all in areas that have nothing to do with pumping. Okay, this is all in the northern part of the county, mountainous range, towards the hill country. This is a well that some of you may recognize. This is the Tularosa well. So now we're on 334 Tularosa Road. And so here in 2016, we saw up, down. 2018, you see a big, large bump for the rainfall. And then this well is 700 and something feet deep, completed in the Edwards. Since 2020, we're not seeing the recovery in the aquifer in the Tularosa well. September 22, we get a bump, and then it's come down. So let's go further down into the county. As we start getting down into the county, this is going to be out 334, not far past the track and field up north of the city. Again, same story. You see a bump in rainfall, you see down. Now this spike here in October, what looks like there on the graph, October 2022, this decline is likely due to pumping. That you saw it flattens out, you saw pumping in the summer, you see a decline, and then it comes back up, we get a little rain, okay? This is now, we've come off the hill, we've come down to the middle of the county a little bit. This is the Dooley well. I don't think I want to go into that, but we started monitoring that we had automated monitoring of that since 2013. This is one that's now south of Highway 90. Here's one, the same thing. Rainfall, everything flattens out. What you're seeing in the summer of last year, we know that this well, it's not pumped, but it is very close to a well that has been pumped. And we saw in the summer, water dropped, it turned off, water came back. Small cone of depression in the area, but you're seeing a response to pumping. This is Mud Springs. I threw this in to highlight something different. What I didn't include is all of this data from 17 all the way to 13, or maybe 12 actually. Mud Springs was dry. I mean, there was no water. I've got pictures of maybe 2013, 14. And this water slides, 15 feet off the ground, completely dry. There was nothing over there. Yet Las Moras Springs was flowing. Olmsted Lake was the lowest it had ever been since the dam was constructed. That side in the western part of the county was dry. Las Moras was not. Today, there is water in Mud Springs. We've had rainfall on the western side that's not getting this way. It's getting low. We're at the end of the summer, but there's still a couple feet of water in the spring. I think the max was about 4, so we're about 6 inches right here, sorry. But there's still water and it's still flowing. There's still head pressure in the aquifer that is bringing water into Mud Springs. And so the spatial distribution about what's happening in Las Moras and what's happening in Mud, it's been different from my observations. This is Pinto Creek. I think Mr. Robinson and I were talking about this earlier. The springs up in Pinto Creek. Without the rainfall, without the recharge, you're not seeing flow in Pinto Creek. Let me keep going here, because at some point somebody was talking about the groundwater district or not doing their job, or y'all weren't doing what you're supposed to, or making decisions, or whatever. This district, since we started in 2013, has been actively engaged in developing a monitoring network, looking at all the data. My background is I believe I try to bring a balance to the environment and property rights and what we're doing. But the goal for us is not to color our data analysis with any type of lens. We're looking at the data. I don't have an agenda and trying to get somewhere with data to support it. I'm looking at the data and trying to let it guide me and tell me what we're doing. And I can say everybody on the board, all the experts that I'm working with, that's our goal. And Director Ward, your prayer earlier to bring us together, we got to figure this out. These are tough times. We are absolutely in a drought. Let's figure out what to do. I want to just bring up some stiff diagrams, and I don't want to I put some some words up here if you can read them. But one of the things that we're looking at what are the flow paths in the county. I know that there was a lot of money spent. EAA spent a lot of money trying to do dye tests. The regulatory requirements to try to do another dye test are going to take a long time. But there are some things you can do for low cost that can give you some general information about general flow paths in the county. And we're looking at a stiff diagram. It looks at the ionic concentration in waters, and you plot them equally, and the cations on the left and the anions on the right. You look at them, and it gives you a real quick visual look. If I take a watershed from here, lots of information, take a watershed from here, lots of information, do they look similar? And it's not the absolute cure-all to everything, but it gives you a general idea, are there some things that look similar? So I wanted to just walk through a few of these. I've got 100 of these, by the way, but I'm going to just, Okay, so on this one, so you look at these waters, and we don't need to go through anything. My point on all these slides is the district is directing us to look at where all of the data, right? So you look at something like this, and you think, okay, the first three, those look pretty good, the next one look pretty good. Well, look at the one down there on the bottom right, it just looks a little different. So let's find some information out why, okay? Look at these three, they look a little different. Well, the one over on the right, I just threw this up. This is actually something from 1952, but there's Las Moras. It looks kind of like this, right? And so you're looking, so as we look at other wells in the county, are there some similarities? And can we determine, are there flow paths directly from a recharge area going down into Las Moras? I don't want to put anybody on the spot, but I know that some of this wells that look like this are pumped out south of 90 that are sulfur water, they're brackish water, and I'm looking at some of the Las Moras stuff, and you think, okay, it's a little different. And so rather than concluding, yes, pumping and Las Moras are absolutely connected, you say, okay, this takes a little more evaluation. And then you go out and you get the data and you collect the information. So this is just another set of stiff diagrams. Okay, let's keep going. I'm trying to go fast here. So the annual pumping reports. We've had a lot of issues, particularly after COVID. It seemed like we were doing pretty good, and after COVID, we realized that what we were getting back wasn't complete. We were spending a lot of time on the phone with landowners and people that had turned in pumping reports, trying to get clarification. What does this mean? You looked at the report and it kind of didn't make sense. You didn't get everything. So we spent on the phone. We spent a lot of time trying to get this stuff and to pull all the data together. Some struggle to complete the process. Meter reading isn't always easy. All of us aren't engineers or hydrogeologists, and some people, they get the meter's broken. There's a lot of reasons why you're not getting it. The form's confusing. Well, the district, this is right after COVID, we kind of getting out of 2021, realized that we need to do something. Let's streamline the process. There's a few ways to accomplish this. There was discussion about automated meters and, getting meters that are reported to the telemetry. And I think, Mr. Conley and I, Will Conley and I, we've had discussions about that. Is this an option for this county? Where are we? I don't think it's practical in all locations. Let's continue the dialogue. I know the district is looking at a field tech coming in. I think, Dr. Bill, you had that on one of your slides, looking at adding a field tech to go out and do some auditing to help out. Pumpers needing to report every month. I think that's going to help. Well, the other thing we said is, how about we just put a web-based app with just a simple form? This isn't rocket science, but put a simple form so they can go to the web and all of their permits are listed. I think there's one permit that's got 22 wells. One permit has one well. One landowner, property right owner, might have 5 permits and 5 wells. And so we did it. It's not ready to go out yet, but if you go to the Kinney County website and you click one of these red boxes, submit groundwater pumping report, it's going to take you to a home page for the district. And if you are a landowner with a permit being held by the Kinney County Groundwater Conservation District, you are going to have an email and a password to log in. And when you log in, your permit numbers, your well IDs, the nomenclature is a little confusing, but this was set up back in a long time ago. But it's all here. you select your year, select your month, put in your meter read. And that information will come back to the district. There's a lot more to this. The district will be able to query and understand how much water pumped out of zone 1 for this month or this range, and there's a lot of other things to do. I was gonna do an online, we can go on the website, I can get it, I can log in here or whatever. For the sake of time, there's no reason to do this now. If anybody wants to understand this more, we can do it later. This is the reporting spot, extracted volume, your permit ID, your well, date range, and you can set the zone on this also. Online demo, no. All right, I'm wrapping up. Seat backs in the upright position, tray tables are up, ready to go. Okay. Active investigation and analysis. This is ongoing. We are doing a lot. Let's talk. All right, here's something. See all these wells? There's 260 something of them on here. We have information, we have digital information on all these wells. Some of them, they're not in addition to our others, but we're processing this. Some of these are very old. Some of them are oil and gas wells that are real deep or not applicable. But we're looking at every available resource to look at data, to try to make correlations. And again, I'm the guy going out and collecting the data. Fortunately, I've got a great team of people behind me, app developers and guys that are interpreting all the geochem stuff. But we're providing the district with raw data, unbiased, and it's going back to the board to make the best decisions we can where we are in the county. And then I'm going to end with this. I know some people don't like me to say this, but this system in a karst aquifer is driven by rainfall. I think the recharge estimates were, I don't want to pull it out. I know it's 106 CFS. I forget what the acreage was, but the recharge on an average year is multiple times more than what's ever pumped here. If you've got average annual recharge every year, there's water in the aquifer. We've seen in this, the last 4 or 5 years, going back, what's that, 2000, I put my glasses on, 2009, last 4 years in particular, you go back into the 50s, you think, well, that looks a lot worse. Well, how much mesquite was in the county back then? I think Dr. Bill talked about the aridity. It's hotter now. How many more hotter days have we had this year and last year than we did the years before? And so we're in a situation, we need rainfall. Rainfall drives the system. A karst aquifer, it's not homogeneous across. There's something over here and something over here. As the aquifer lowers, water goes different directions. That's my presentation.
Dr. Bill. Will, you have any questions for Dr. Bill?
Yes, I think I wanted to just make sure, just for a point of clarity, we're saying, I guess, first question, is pumping connected to Los Moras sprinkler? I know this is rhetorical.
That was slide 1.
The answer is yes.
Of course.
Okay.
I've never said different.
You have never said that. I want to back up on that. You've never said that.
Well, then why is it published that way?
Well, a lot of board members and people in the community have spread that information. And people believe that it comes from you, that it comes from the board. So I think that it is important to clarify. It is important to clarify that what we're saying here is that pumping is connected to the spring. And it sounded like, based on this initial look, this model, we're saying that if we had curtailed 75% of pumping based on the current estimates of pumping.
No, that's not right.
Okay, what is that?
No. There's a bad habit that I've seen where words get put into someone's mouth. That's why we have papers printed that misquote me. That's why the Texas Monthly article was the way it was. I did not say 75%. I said 4,000 to 5,000 would result in about 5 CFS of spring flow. That's based on a data analysis. That is not 75% cut. That's a 50% cut of 2022 pumping. It's a 75% cut of the historic maximum.
Okay, so
The
75%.
problem is that when you're dealing with these percentages, what's the baseline? That's the whole point of this.
Sure.
We have a baseline problem because irrigated acreage fluctuates, pumping fluctuates. The EAA is a big enough system where you can talk about those kinds of percentages and have them be meaningful. Here, they can be used as weapons. And so I caution you to make it clear. My evaluation was 4,000 to 5,000 acre feet, resulting in about 5 CFS of spring flow.
Okay.
And as soon as you do any percentages, you can get into trouble very quickly.
Okay.
And let me add to this real quickly, because it's a practical matter. We have the exact same problem in multiple districts, most specifically Hayes Trinity,
Yes.
Hayes County. When you talk about a percentage cutback, you have to say, as I said, the baseline's important. Percentage cutback from what?
Right.
From what their permanent amount is, from what they've been using, what they used yesterday, from what they
Right.
used a year ago.
I think that's.
Those are all different numbers, and so trying to do a percentage cutback, you gotta say from what?
I hear you. I think that's a logistical issue. I feel like we can overcome that. The question here is whether or not pumping is connected, because that has been a question in this county for as long as we've had this.
The problem, the origin of the problem is that the question that was asked in July of 22 was if the pumping were to be cut back, would the spring come back to average level? And my answer then and my answer now is no.
And I don't think that anyone has said, well,
Yes, they have.
I have not heard it, but what I think that needs to be clear is that what we're saying, we're agreeing, is that pumping is connected to the spring.
It always has been.
Okay, and I agree with you. Now, we're also saying that 5,000 acre feet of cuts.
No.
Whether they're.
No.
I'm asking the question, I'm just asking you to respond, we can shake our heads and get upset, I'm just asking questions so we make it clear.
Now, the problem is the questions that get asked then get twisted into things that are not true.
I'm asking for confirmation, so.
The confirmation is right there. If pumping were to be 4,000 to 5,000 acre feet a year, then you would get about 1 to 8 CFS flow during a drought. And I've provided 2 estimates of cutback. One based on a baseline of 22 pumping, and one based on a baseline of total permit limit that was defined by your group.
So the 5,000 acre feet that you're saying, that's how much you are pumping, which is it a reduction or is it what we're pumping?
2022 pumping was at about almost 10,000 acre feet a year.
And so what we're saying is a 5,000 reduction, which gets you to 4,000 to 5,000, would result in a 1 to 8 CFS increase of
I
spring.
don't mean to be short, if you will, but this is part of the problem that we're having. We're trying to build a transparent set of data and a discussion at these meetings. We've done this now half a dozen times, I think. Every time we try and go through this information, then in the Kinney County Post, and I don't have a Facebook account, but I hear about it, stuff gets twisted into unbelievable contortions. And this is part of the problem. You're playing essentially a lawyer game of twisting words to get me to say something or to, in an attempt to supposedly understand it better, you sort of rephrase it and then it gets very badly twisted. This is what I'm saying. The slides are what I'm saying. Review the slides. Yes, pumping affects spring flow, but there's a lot more to it than that, and trying to twist it into certain percentages can be a very dangerous game when you're doing it like it's being done.
I'm not trying to twist your words, I'm genuinely trying to understand. If I can't understand, I don't know how anyone else understands.
You can't understand that pumping is connected to spring flow, period.
No, I understand that. I'm asking you if it's a 4,000 to 5,000 reduction, or are we saying it's 4,000 to 5,000 acre feet that we're talking?
I think we're going nowhere. You got a question, Ellis?
I think that, this way where we're not answering questions. If it's a basic question, are we saying that a 5,000 acre foot reduction results in 1 to 8 cubic feet per second?
So would we have water flowing if the pumping was 5,000?
If the pumping was 4,000 to 5,000 acre feet, you get 1 to 8 CFS during a drought. In 2022, there was about 9,600 acre feet of pumping.
Okay, and so 9,600, if we reduce that to 5,000, is that what we're saying?
Except the fact that in 21, it wasn't 9,600, it was something less. In 2012, it was about 4,500, and we did see a little bit of spring flow.
Okay, so
This is not a simple answer. These are generalizations. Remember, the point of this was to establish sort of a baseline on which we could base, or we could evaluate the model results.
okay, and so if someone were to say, what would 5,000 acre feet of reductions increase the spring flow? Do we have that?
Yeah, if you reduced, if in 22, pumping instead of being 9,600, it was 5,000 less, you'd have probably gotten somewhere between 1 and 8 CFS of spring flow.
Okay, that is what I want to clarify.
All right.
So we're saying that spring flow is connected, and that we would have seen a 1 to as much as 8 cubic foot per second spring increase in flow if in 2022 we had decreased pumping from 9,600 acre feet to 5,000.
So between 4 and 5,000.
Between 4 and 5,000 acre feet.
Right.
Is there any area in the county that, in your opinion, is not connected to the spring?
Yeah, zone 3.
And is zone 1 and zone 2, are they connected to the spring?
Zone, based on the analysis on Jim's monitoring well network, zone 1 is strongly correlated. Zone 2 is moderately correlated.
Okay.
So there's a contribution from 2, but it's not as strong as 1.
Okay. And then what percent of pumping reports, and you've gone through them all for this model, would you say are complete and legible over the past 10 years?
Are what?
Complete and legible pumping reports. How many, what percent rough in the ballpark?
I did not physically go through the handwritten reports.
Okay.
I analyzed the data after that work had been done.
Okay.
And that's what we're trying to avoid in the future with the app.
Do you have any experience looking at them to where you can make an estimate of ballpark, what you feel like probably was roughly the percent that are being completed over the past 10 years and then turned in?
I have reports for, there's 47 historic and existing use permits. And I have a data point for each one.
So what percent of the monthly reported flow would you say that kind of turns out to be?
Well, there's no monthly, these are annuals.
Okay, so
I
you
have,
have
the data I'm working with is annual, that's why we're asking that they be monthly reports.
Okay, and so you have, does that mean that there's 100% of the report? I'm asking for a percentage. And your answer makes it sound like
I am not going to answer a question on work that I did not do.
Well, you said there's a data point for everyone, which makes it sound like you got all the functions.
Yeah, some of them were broken meters, some of them were missing data. I'm just saying what I received.
Would you say it's fair to say that many reports are not turned in?
I think they all got turned in eventually. I don't think a lot were timely. I think we've got, I don't know. That's not what I've been doing.
Bill, is there anywhere in here where you're figuring in, factoring in the discharge from existing springs in Kinney County and the discharge from all of the, I don't know the count on exempt wells in Kinney County, which would include the city of
The
Raggedale.
groundwater model takes all that into account. This is a relatively
But
simple
we have to
data
do that for
analysis.
this, don't we?
Yeah, the numbers are going to be relatively small. The domestic wells are not going to be a big contributor to anything in terms of impacts to the spring.
How many are registered here?
400, something like that. I don't remember the number off the top of my head.
Curtis, you have a question?
Oh, I was just saying, this is a godly thing. It's a drought. We're gonna go through it, whether we pump or we don't. Those springs will go dry, they will come back. But if we say, it's a good Lord thing.
That's not what he just said, though. He just said if we didn't pump that much, we get 1 to 8 feet, not wait on God to see it. We're ready to do it.
He stops chunking. He's investing in it. He's doing the best he can for him. Even if he does this, it may not.
Well, all I can do is go back to the record. And during droughts, during the 50s drought, there was about 5 CFS of flow. There wasn't as much pumping back then.
Hutchinson, I'd like to ask you a couple of questions. Do you mind? I'd like to ask a couple of questions. One, there's a lot of talk about pumping affecting spring flow, which I think everybody realizes that happens. Is all pumping in Kinney County negatively impact spring flow?
No.
Thank you. One other question. Is correlation the same thing as connection?
No.
Thank you, sir.
I just,
Question, Doctor. When you said that the 4,000 to 5,000 on the pumping, you would correlate to some spring flow. What zone? Obviously, according to zone 3, that 4,000 to 5,000 would not be in there. You're talking about 4,000 to 5,000 in zone 1.
Zone 1 and 2.
1 and 2 combined.
Right. Because the
combined, they only pump 4,000 to 5,000. Then it might result in some spring flow.
Right. Remember this.
Zone 3 only had the one well that doesn't pump.
Charlie, these are zones 1 and 2.
Right. Yeah, no, I'm with you, but you know, I wanted to see where you would direct that 4,000 to 5,000, but it's in zone 1 and 2.
Right. Zone 1 and 2 is what's connected to the spring.
Okay.
So there we're talking about, see the spike in 22, thrown up over 9,000. And down back in 13 and 14, it was, in the 4,000 to 5,000 range.
Is it possible to break that further into zone 1 and 2? Like, in other words, zone 1 obviously said was directly correlated. So of that 4,000 to 5,000, does it matter where it comes in?
It matters very much, because if you notice this, in 2013 and 2014, when it was between 4,000 and 5,000, most of that pumping was in zone 1. But when you go to 21 and 22, 2021 and 22, zone 2 has a very big component of that total pumping. Well, that's where you had a dry spring. In 13, when it was all in 1, there wasn't a dry spring. So it becomes, in that sense, it's a little counterintuitive. That's where the groundwater model comes in. That'll help answer those kind of discrete questions. Again, the point of this analysis is to say 1 to 8 CFS. So when I run the model, if it says no recovery, well, the model's got a problem. If it says 15 CFS recovery, the model's got a problem. So this sort of helps bound everything to make sure that we're doing things appropriately, that then gives us license to then start saying, okay, what if we pump here? What if we pump there? Trying to get a better handle on the flow paths.
I have a question. Thank you for the presentation. You mentioned that the model available groundwater is incompatible with the DSC right now.
Right.
And that the map is way overpumped compared to how much is pumped and how much has been pumped in the past 2 years in the county. I'm wondering if you can tell us when the period for revising the map is and who those governing bodies are, if we have to determine it through the board and then pass it off to Region J or
No.
what? And then another.
Let me answer that one first.
Okay.
The DFCs are set by the groundwater districts within a groundwater management area. GMA 7 and GMA 10, Kinney County is in both of them.
Mm-hmm.
The spring flow is in GMA 7. The next round of joint planning, the statute requires that a new DFC is proposed by May 1st of 2026. Then there's, let me finish. So the proposed DSC is May 1st of 26. Then there's a public hearing process. Then the final adoption and submittal to the board is by January 5th of 27. Once that is all submitted to the board, then they take that DFC and turn it into a MAG. They calculate the MAG. Well, part of that process is to get this model done by 26, have it all approved by the board, so they can use the new model, so that if, let's say hypothetically, we have the same DFC, the spring flow, then they'll run the model and come up with a MAG that's more appropriate in terms of actual historic pumping, not permit totals.
And might that look somewhere closer to 4,000 to 5,000?
No.
I'm sorry, can you answer why? Because it seems like 4,000 to 5,000 is the amount pumped, which is still.
If the 4,000 to 5,000 is the MAG, then what you're doing is protecting summer drought spring flow of 1 to 8 CFS. Is that what you want?
Yes, we love it.
Or would you like to protect the historic use?
No.
The historic spring flow, which was like 22 CFS, which would then mean that you have to take essentially the average of all the years of pumping, which would be somewhere in the, I don't know if I actually ran that number, the average of all the actual use, which would be, it turns out to be the same, about 4,500, that red line would be about what the MAG would be if you wanted to maintain the current DFC.
Okay, sorry, that's correct. And then I have a question for Jim really quick. If Jim's taking questions, thank you for your presentation as well. For the portal, that's a nice system set up there, and I'm wondering if it's possible to have an option for landowners to upload a photo of the year.
It's in there.
Is it a mandatory photo, or is that a voluntary?
That's gonna be up to the board, but there is a photo option, and I'm not gonna speak for the board, but that is in there.
The springs have stopped at Fort Cox, but the well where they get their drinking water, what level is it at? Is it down?
We don't have a monitor in that well.
Yet.
It's physical construction that they were willing to let us put a monitoring system in there, but the way it's physically constructed, we couldn't get the probe in the casing. Based on what's the bracket bill?
From the city or mud?
Yeah,
I think. Oh, this City Well 1, which is in the yard, and City Well 2 is the tower.
What's the depth of water there?
Oh,
it's about 20, isn't it? I don't remember the numbers. It's relatively shallow in town, so it should be it's probably relatively shallow.
I mean, last time we wanted to fill a pool, the mud said it was like 19 feet.
Yeah, you're
within below 25. They want to start restricting. So it was at 19 feet.
He's saying right now it's about 19 feet, and they get concerned when it gets below 25 because of the upsetting.
Right. But everybody at Fort Park still has drinking water, right?
Yes, ma'am.
Okay.
Yeah,
So,
it's within 20 feet from the surface.
Go ahead.
Water is within about 20 feet from the surface.
Oh, is there a well?
Yes, ma'am.
Is there drinking water?
Yes, ma'am.
So is that a good height?
It's very close to the surface. It's not quite enough to allow the spring to flow, but the water is very close to the surface.
Below 25 feet, they want to restrict. They consider restricting.
So the springs at Fort Park have gone dry, but is everybody just as concerned about the Pinto and the springs on the western United States?
Absolutely.
Jim just showed Pinto and mud.
Okay, so everybody's dry.
Yes, ma'am.
Yes.
Not
That's on Felipe Springs, it's just 10, 15 miles.
All right, San Felipe, I'm glad you asked that, because the woman that asked that is gone.
That's real close, it's the same.
That's connected to Amistad.
Yeah.
We did the study 10 years ago, we did a big study for Val Verde County, we had the city of Del Rio.
What's
And-
the difference between
San Felipe.
10 years ago, we did a study in
San Felipe?
San Felipe Spring. Before Amistad was constructed, San Felipe was relatively small. And when Amistad was filled, San Felipe went gangbusters. And the water level in Amistad and the flow in San Felipe correlate almost perfectly. You've got a karst system just like here. It recharges, water leaks out of that lake and comes out of San Felipe. So San Felipe is not a good barometer of anything related to drought anywhere in the region because of Amistad.
Yeah, because it's never dry.
It's never dried. If Amistad dried up, San Felipe dried up. That's its source. It's not a natural recharge-driven system like here. Yes, ma'am.
So one of the questions I have is, and I'm sure perhaps it's somewhere in the water management plan. So when I look at the U.S. Geological Survey flow data.
Yep.
For 2020, 2021, and 2022.
It's dry.
And I try to correlate that against the TMC, which is 24.91 and 23.9 the other. It doesn't make sense to me.
Well, you gotta read the plan. If you read it,
That's what I'm asking you, sir. Where is it in the plan that specifies that more than?
Section 5.8.1.
Okay.
It's right there. This is what we went through in October with the management plan committee. Were you there? Were you there? Have you read the plan?
I have read the plan.
Do you know anything about indexed compliance?
That's what I'm asking you about.
All right. So.
I mean, is it a rolling average?
No. What?
December 31st.
December 31st.
Yeah.
December 31st.
Based on the technology that's coming.
Let me answer. On December 31st, there's a spring flow. You take that spring flow. Then you compare it to the annual rainfall. That's what these points are. On the x-axis is the annual rainfall. On the y-axis is the December 31 spring flow. They should plot between the green line and the blue line based on the historic data. As long as you're within those bounds, that's considered within acceptable range because all of these points together average 23 CFS. So it's confusing because people see the average, they think it's an annual average or a monthly average or something like that. No, it's an average over many, many years on December 31st. This is how we have applied it for the last 12, 13 years. It can be updated and changed when we update the DFC in 2026. But I think it's unfair to claim that there's no information on this when it's very clearly laid out in the management plan. It's been discussed since 2013 in each management plan on how this went. This is what the graph looked like with the old gauge. The old gauge, this is the graph we used. Then we had the problem, we have the new gauge, then we had to scramble to make a new graph because the data are different. And the data availability are different.
So what you're looking at is average rainfall.
No, annual rainfall.
Annual rainfall.
And December 31st spring flow.
December 31st spring flow, and so how does that relate to the spring flow?
In the summer, it doesn't.
During the year.
It doesn't. That's the point.
So the spring flow during the year.
As long as
fallen over time, so that if you took an average spring flow during the year and come here and went back and looked at history, and you would be able to see that it's declining.
because the model, this was all this DFC and MAG stuff is based on a model. And the model, in this particular model, it only looks at the point once a year. If you have a model that looks at it every day, you can do that. If you have one that looks every month, you can do that. This model, we're limited because it only looks at things once a year.
So Bill, you could really never get below the DFC until you have many years in a row.
No.
Below,
No.
because that's what it takes to
No,
bring this.
because
this
here's what would happen. Let's say Mr. Water Export comes in and starts sending tons of water to Laredo. Pumps 20,000 acre feet. But it rains a whole lot. We got a 30-inch rain. If the December 31st spring flow is 10 CFS, we're outside of bounds.
So just one data point being assessed balance enough to be assessed the DFC, not an average.
Correct. Each of these points is the individual year. So technically in 2014, we were a little bit below the line, but it was so close, and there were, 2013 and 2011, we were just coming out of a drought. It wasn't something that we were going to get too concerned about, because in 2015, it was way up here. And then, in 2018, we were over the line. So this is an annual measurement that will be done. It was done in May of May of 23. I'll do it again in May of 24, May of 25. And by May of 26, maybe it'll be on the new system.
That's very helpful. I guess it's been real confusing.
Did you come to the meeting in October when we went through this? Travis was there.
I can't remember.
Travis seemed to understand. Travis was there. I explained it then. He seemed to understand it and accept it, given the limitations of what we were doing and how we were doing it. This at least looked at it once a year to say, because if you had all this pumping during the year, that red dot would fall way below the blue line, and that would be a problem. And that's what we're trying to fix with the DFC problem.
I think that's helpful. I think that people, I think might argue that, and this is no fault here, this is just how you're running the program right here. I think people feel like it could be deceptive to say that we're at our DFC, we're only using December 31st data point. You could have zero flow all year, and if you had 20 cubic feet in December, it would make it look like we hit it. So that's just not the way it's being run right now. But I think that probably would be a good improvement.
I'm sure people could come up with all kinds of criticisms.
Is December 31 arbitrary?
Well, it's just the end of the year. The model is run on an annual time step.
Can we change it to a time when the pumping is occurring?
I can run the model. When you set up a model, the one I'm doing right now is quarterly. Monthly models get very messy very quickly, especially in this kind of environment.
Well, I know we
I've got one model I'm reviewing now. They actually ran it daily, and it's a complete disaster. I'm reviewing it, and it's unworkable. The quarterly things behave well in a car system. Monthly, they can get very messy. Annually, they work very nicely. Yeah. But annually, you run into this sort of problem.
That makes it look good to run that on December 31. And I know we don't irrigate in the middle of December 31. I don't know how many people irrigate.
Surprisingly, that was one of the things that surprised me in the satellite work is there's a fair amount of winter irrigation going on. A lot more than
on December 31st.
Well, no, I mean just in the season, because the idea is that if you're doing a lot of pumping in November and December, that's going to have an effect. That's why you see some of this scatter.
Bill, can you, and I think this is going to go to Will's comment, but can you explain that the model that was done in 2010 that is based on this end of year DFC, that was the model, was the Texas Water Development Board?
Yes.
Yeah. So that was a model that was developed.
Well, I was involved in it.
But at the time, annual time steps were what was being done. And so they had
no, that's not true. I did one in for Barton Springs that was monthly. The problem with Kinney was we had a very, very short time frame to get it done to meet the deadline, the September 1st, 2010 deadline. This was done very, very quickly. Darlene will attest to that.
Yeah, and Bill, I'm truly not criticizing you for this, for having it set up this way. I think that it is very fair to highlight the weakness here, that we are showing the end of year spring flow, December for the best month for spring flow, and we are representing the entire year with that end of day spring.
You'll forgive me if I take your words with a little grain of salt, given what's happened over the last couple months.
But would you agree that it is a misrepresentation of the year to have December 31st representation?
I'm not
I think that's a very fair question.
I think I've made it very clear, this is how we do it. It's an indexed compliance based on a single point in a year and the annual rainfall to get a general sense of what the effects, if there have been any effects from pumping on the system, above and beyond that would then create a problem with meeting the DFC of trying to meet the historic flow. And since the historic flow goes up and down all the time, you're going to have to capture it at some point, and you can be criticized for doing an average over the year, an average over a few months, anything you do in this system. And I'll tell you, there was 9 years of arguing over how to do an index compliance in the Texas-New Mexico case with a lot of people and a lot of millions of dollars involved. And everyone will have their own opinion on the best way to do it and twist it into this is, not appropriate, and it is not a simple thing, but it is very commonly used everywhere in water resources administration. So to try and simply distill it down and then put it on Facebook or the Kinney County Post, that'll get twisted into something else, it's gonna happen. I know that. I'm just trying to explain it in the simplest way I can, that this is the way we do it. We've been doing it this way in the management plan since 2013. It's been accepted by the Water Development Board. They have to approve these things as administratively complete. We've never had a comment about this sort of approach. And are there better ways? Probably. Are there better ways with the available data we have? I haven't figured it out yet. Maybe you're smarter than me and can do that. I don't know.
What is the argument against using the yearly average?
Anytime you use an average, you saw the problem I had in trying to deal with the annual pumping and the spring flows and all those averages and those sorts of things. You lose some of the reasons. We see month-to-month variations. We see the month-to-month variations, and that causes the scatter in the data. And as long as you're sort of within those bounds, you're sort of embracing whatever month-to-month variations there are in rainfall, evaporation, pumping, all those things. As long as they don't go outside those bounds, we're fine. As soon as you start labeling everything into a simple average, then the slightest deviation, people start getting themselves all worried about it. And that's where you can get into trouble because you're over-interpreting something. This is not an over-interpretation because we're sort of embracing the natural variability of the system. Now you could do this when you plot these sorts of things. Well, here's the thing. That's a mess. That's the daily data. Now, if you tried to model that on a daily basis with everything else that's going on, you will lose your mind. You can lose your mind on a monthly basis trying to do that. That's why I went to the quarterly on the model I'm doing now. So as soon as you start averaging things on the results, then you've got even a bigger problem. Yes, sir.
When you're talking about wells, are those irrigation wells on farms?
Yeah,
or are you talking about domestic and stock wells?
For what, pumping or monitoring?
Pumping and monitoring.
The permits are the irrigation wells that are pumping.
Okay.
We do not permit domestic wells.
Well, they pull a permit, but you're not monitoring.
Well, it's a registration.
Okay.
They register them, but they don't permit the production.
But then you got 3 other wells.
I've been out here over 10 years working on wells, and there's a lot more straws in the ground up north of here.
Yes, sir.
Than there were 50 years ago.
Oh, yes, sir.
You can't tell me that doesn't have an effect.
You're
Because there's some of those that I've done
pump 24/7 into the stop tank. Right there. Edwards County in 2020, 805 acre feet of use. Kinney County, 5267. But we know in 22 that bumped up over 9,000. We know that Edwards has a lot more use now. That water normally comes south to Kinney County, and as that area in Edwards County grows, that cuts off some of the water that normally, historically, had come into Kinney County. Excellent point.
So with that being said, August 23rd, under rain, inch and a half, 2 inches, fair enough disturbance that came through. Okay, I cut off for a day or two. It was hot the next 2 days, and it was hot. Wells all turned back on.
Right.
They didn't pump any more water. Then a week or so went by, 10 days, spring started rising.
Right.
So how do you explain that in the model?
The spring,
And, you know, whenever the wells are pumping, it's not a direct correlation.
right. It takes you're exactly right. There's a lag effect.
Because my water didn't get
In, right.
down for a minute.
You remember in July or August of 22, it was the springs had been dry. The dueling well was down over 20 feet below ground surface. We got that 7 inches of rain, and it took about almost a week before the spring would start flowing again. Then it kept getting stronger and stronger, and then eventually it quit raining, and the spring started to decline. And this is one of the problems with what I was talking about, the daily model or the weekly model or the monthly model. There's a lot of that kind of stuff going on that the model is as a resource tool, water resource tool. All that individual stuff that's going on in the short time frames isn't really relevant to the work that this board has to do. The annual model, all those things kind of smear out. The quarterly model is kind of an in-between where it actually, you can still see things where you don't have to worry about that week or two lag. Now you're averaging over that time period.
Okay, so with that being said, then, like what Will was talking to us earlier is, okay, when he was saying you play 4,000 to 5,000 acre feet a year, you're going to gain this much. What he was saying.
Right.
Well, how do you implement that with rain and that throughout a yearly basis? The product, not a day. How do you divide that 5,000 acre feet? You can't just go straight to it. It doesn't work.
That's the whole point of how do you implement curtailments? If you have an analysis that shows if pumping was 4,000 to 5,000 acre feet a year, you get this little drill out of the spring. Okay, that's nice. But now from an administration standpoint, what does that mean? Do you cut back from the last year? Well, what if last year y'all only pumped 3,000? This year was unique, 9,000 or 22, 9,600. That was more due to the heat. This year is probably going to be about the same. So how do you decide what the cuts are? Is it from the previous year? Is it over some period of time? But when you do over the period of time, with the irrigation, the satellite analysis shows irrigated acreage goes in and out. Having that baseline is the most difficult thing to get your handle on. It's a nice academic exercise to run the model and say, oh, 4,000 to 5,000 acre feet of pumping, we get this little dribble of spring flow. That's great. How do you administer that? That was the whole point of the last set of the slides was, what's the baseline? How do you deal with it? That's the kind of stuff we're gonna have, the board and I will have to have more discussions. Yes, sir.
How do we know how much the Kinney County goes to drought? Because your arrow went down and went.
Yeah, it changes. Yeah, that's the thing.
57,000 acre feet.
No.
5,000.
Those are just the pumping numbers. That's not the amount flowing in. We know that there's flows straight north to south, but over in the northeastern part of the county, it actually kind of turns. The dye test study shows that moves. In other words, it's not a constant. It depends on if the water levels are up or if they're down. The problem was when they first got started on the dye study, it was a fairly wet period, but it takes years to do that. The drought hit in 2011. So that was the condition associated with drought. But then we thought, okay, how do you do the test again in a wet period? Well, let's predict what's wet period again. It makes it very difficult. But we do know that these flow patterns are dynamic. They change depending on where the water levels are. And that depends on, there's some spatial distribution. Sometimes it rains in one part of the county and not another. So on an overall basis, a 20-inch rainfall year could look very different depending on what part of the county you're in.
How do you explain annual wells? They're still under pressure.
Everybody's under pressure.
No, I'm saying,
They're flowing.
Yeah.
Water levels are up. Well,
I'm just saying, the springs are.
Yeah. So remember this diagram. This is pretty cartoony. But if the water levels are above ground, if the pressure level is above ground surface, you get flow. If it's below it, you don't. And then the Dooley well, we've seen periods where it's been above ground surface. And so that depends on where, that's more of a localized condition. And Daniels is, they're in zone 1, so it just depends on what's going on over there at the time. Because even while the spring is dry, we know that for Clark, the water level is only 19 feet below ground surface. So over by McDaniels, the water level is high enough that it still causes a bit of a flow. It's just within the natural variation.
Pinto doesn't flow.
Bud's flowing now. Bud's still got some water in it. Pinto is a little low, but it's very close to the top. It just right up wet, middle of the summer. Where it had wet for a while before that.
All I know is all those wells are straight line from the southwest.
Yep.
And very straight line, very narrow. I think the system back there.
Are all your pumping numbers there, are those inclusive of all aquifers or just strictly to Edwards?
That's Edwards.
That's Edwards numbers.
Yeah. Well, no, I take that back. There's a few wells that we think are some of the collections could be lost in chalk. That's where it gets a little confusing down there. Okay. These were all in zone 1 and 2.
And can you is there a correlation between spring flow and pumping from loss and chalk?
In those that's why they're in zone 2. There's a moderate correlation. In that area, it was difficult. In zone 1, it was pretty clear. In zone 2, there seemed to be a good correlation, and some of those were some of the ones where we weren't sure how much of the production was coming out of the Austin, how much was out of the Edwards.
And that probably changes as pressure in the Edwards case.
Exactly.
Dr. Bill, can you repeat what 805 changed to? Is Edwards County is the one north of here, I assume, and your slide was 2020, it said 805 acre feet. Did you say it went up a pretty good amount in the last 2 years?
All we know is
like the estimates of what's coming from the north.
Yeah, all we know is what is in.
Yeah, it says you were talking about seeing more wells up to the north or whatever. So the slide of the counties where the arrow was, it said 805 acre feet.
Yeah, that was the use.
And then that was in 2020.
That was the reported use in 2020.
And then what are you thinking it is like now in 2020?
I would say higher only because it's been hotter. We know that Kinney went from 52 to 96.
Right.
Well, it's probably a little over 10,000 when you count everything. The city pumping and all that. So obviously, the point of this graph wasn't the specifics of the numbers. It was that the opportunity for growth to the north will have an impact on Kinney County.
Right. Okay. Thank you.
Yeah. Yes, sir.
This can go on all night. We're just gonna move to the next item.
Okay.
I want to thank everybody for their participation. It's going to be a constant deal until we try to figure out some more information about this. So I want to thank y'all for coming out. We're going to go ahead and finish the item of those issues. Let's move to the next item. This is number 9, discussion and possible action. Authorization, authorize the general manager.
Authorize the search. I make a motion, we authorize the search and post that job opening, bring suitable candidates before the board.
This meeting is over. Please be quiet.
If people want to talk, if y'all want to talk, if people want to talk, y'all can go outside. We're still conducting this meeting.
Matthew, I want to, just as on behalf of everybody that's here, we want to thank the board for y'all having this. It's been very educational for me, but I appreciate having an open forum like this. It's excellent. We need more of this because people understand things better.
Yes, sir.
And if we understand things and have that knowledge, we can make better decisions.
Yes.
Well, thank you very much.
Thank you.
Thank you.
Thank you.
There's a motion in a second.
All right, let's go back just a second. It was the discussion of possible action on authorization to let the general manager to hire a field technician.
No, not the general manager. Board will hire.
So,
Make a motion to set the, post the job open, as we discussed on this list. General manager will bring suitable candidates before the board.
that's the motion. Who made the second? I did.
We're gonna take a vote. Because we haven't had any public comment yet, and let's ask for public comment on that issue, please.
Is there any public comments on that?
We can't hear what you're saying.
Agenda item number 9.
I know that. I just can't hear what they're saying.
We need,
We're gonna, the plan is to hire another person for the board, whose, job will be split 50-50 between the office and out in the field. They will increase the monitoring. And we have somebody that will go around more often. Also, they're gonna help us on the app, help us on the computer that need to be literate in the, GPS and anyway, we're gonna have somebody else to help, but it will increase, our monitoring, hopefully both in quality and frequency. So that's what we're talking about. We're gonna post a job opening, to hire somebody for, an additional somebody for the district.
Thank you.
basically, it's a field tech. Do I have any? Yes, ma'am.
I just want to say, I think that's an excellent idea. That was one of the things that when I went up to the Rangeland Water Conference in Sutton County last week and got to hear their presentations, it really seemed to help their general manager to have that extra resource, to be able to go and deal with things in the field and do more of the data, like data correlation and stuff like that. Not like you would have your consultants do, but there's a lot of things that, someone can do on a helpful daily kind of basis. So I think that's a great decision on it. Just hopefully they have some good qualifications in that area.
Sure. Anybody else?
I'll just say, I second that. I think that's a great move that y'all making. Appreciate that. More information is always better.
Yes, sir. Thank you. Anybody else? Just, a second. So we're on each side of motion. We don't have to. Don't need a vote. Everybody in favor?
Yeah.
Motion passes. Yes, public comment.
Can I get three chairs? Three
Yeah.
My name is Wes Robinson. I'm a Kinney County resident.
I hold a surface water diversion and groundwater permits within.
Now they're turn around so people can hear you.
I don't have to turn around for you. You can come up here. I'm addressing the board.
Time for you to go have supper.
Yeah, time for you to go home. Anyway, I represent myself. I'd like to apologize for my behavioral dog this meeting. My skin's a little thin as I've aged. I'm a little less tolerant of half-truths, misinformation, and people that are just bald-faced lying. In any event, I'll endeavor to keep my composure for the time being. I'm also sorry I was not in attendance at the last board meeting. Unfortunately, I was out of town. I have watched the video of that meeting. I've known some of you most of my life. I've known others of you. I've gone to school with you. Some of you I've only come to know in the last couple of years. But I do believe that each and every one of you are good-natured and kind-hearted people. And I think you've all expressed a willingness to find answers and provide answers for finding the solutions when they're presented to you. And I appreciate that. I want you to know that. I really, really do. And I feel the same way about the staff. And Mr. Ellis needs to definitely take a sound back because he would never believe I would say that about him. I also believe that those same admirable traits were used against you September 13th of this year. I'm here to talk to you about public comment. I'm a former alderman for the city of Brackettville, during which time I served as mayor pro tem. I'm a former board of director for the Kinney County Appraisal District, and I'm the former chairman of the Kinney County Historical Commission. In addition to having attended hundreds of public meetings as a reporter for the Bracket News for nearly 2 decades. I'm not mentioning these experiences to be pretentious or feign expertise in any way. I'm mentioning them to you so you know that I've had experience on both sides of that table. I've had my victories and I've had my failures on both sides of that table. Public comment is exactly what it says. It's the public making a comment to a governing body, usually voicing a concern over an agenda item or proposed action, perhaps a thank you to the board, for the staff, or even a tongue lashing for some perceived slight of duty. Public comment is not a forum. It's not a pulpit to preach to your followers. It's not a Q&A with the board. And it certainly shouldn't take up 2/3 of your business meeting, ever. Public comment is for the public to inform the governing body. It's not for the governing body to inform the public. If the board desires to have an open forum for the public, that's great. That's y'all's decision. You need to do that in a workshop. You don't need to do it in your business meetings. They don't need to last for 3 hours. The board was baited through an orchestrated attack into a debate with the Lost Moras Springs Conservancy Association during public comment September 13th. How do I know it was orchestrated? Because at 3:24 on the timestamp, Ms. Brown asked for LMSCA members to be allowed to speak in a pre-designated order. In addition, there was this video in the meeting and posting it to YouTube. At 4 minutes, first speaker Elizabeth Hodges informed the board the Lost Moras Springs Conservation Association is, quote, a group of people with no formal chairperson or rigid structure. It's not an entity, end quote. It's not an entity, you can't hold membership to it. It was a false statement. Lost Moras Springs Conservancy Association is a 501c3 nonprofit established in 2022, located at 1930 Glen Oak Drive, Corpus Christi, Texas. According to bizpedia.com, it has 4 directors: David Conley, William Conley, Wyatt Conley, and Wilder Conley. This information is readily available through a simple Google search. By the way, they also have a private Facebook group and a YouTube account. These supposed members of the Lost Moras Springs Conservation Association have made it abundantly clear their only interest is in restrictions, enforcement, proposing rules, many of which have no foundation in law whatsoever, and attempting to strong arm the board during business meetings. What these members apparently don't know is groups like theirs are subject to regulation and oversight as well. If they continue to video, they intend to continue videoing and posting their comments at district meetings in behalf of the Lost Moor Springs Conservation Association. I would advise them to be very cautious in their statements, because they could very well be incriminating themselves as well as their directors. To the board, I recommend you quit kowtowing to supposed members of a group that don't even know what they're a member of. Thank
you. Suzanne Mann?
Yes, sir?
Did you register this?
That was the only comment during the meeting.
Okay.
Well, yeah, I think that if we're a 2,500 person town, I think that we can have a conversation in these meetings. That's probably the most productive thing we do in these meetings. It's just really the only time where we have opportunity to talk about these issues with you. There's been a little bit of this, 3 minutes. It hasn't been strictly enforced, and that's appreciated. 3 minutes is not a long time to give public comment. I think that asking questions is extremely helpful. And, very clearly, the goal here is to prevent any sort of being able to voice concerns, being able to have these conversations with the board, because there's a desire to snuff that out to disenfranchise people from being able to communicate with the board. So I just disagree very strongly with Wes that it is a bad use of our time to have conversations about conservation. And, yes, it's a 501(c)(3). I don't know why that is a negative thing to have a charity for the Conservation Association. But that's my comment.
Thank you. That's all the comments we have for tonight from the individual sign.
I want to say something, and this is kind of following up with Wes. I didn't even have an idea that he was going to do that. But on social media, Ms. Brown, both Dee Dee and Gage, keep calling out the Hondo farmers. They are just a small percentage of permit holders. Everything you put on there, you're putting false information out there. You're setting yourself up for a slam.
False. What did we say that was false?
I cleared it up with her. Okay? You put on there that Judge Schuster, which you really owe him an apology, a public apology.
Really?
Yes, you do. Because he wasn't even on the board when all of the Hondo people came in here and moved in here and got their permits. And if you were a realtor at all, you would know that when you buy irrigated land with permits on it, it comes with the land. He didn't hand it out to anybody. We bought that. We paid for it. We paid taxes on it.
Yes, I realize that.
But that's not what you put on social media.
John Paul did
Hold
not
up.
issue a permit.
No,
John
he did
Paul
not.
converted a permit.
He didn't to
For
us.
different use.
He didn't to us. He wasn't even on there.
I'm not going to spoke about the permit.
Yes, you did.
I did. But I've lived here my whole life.
So that gives you the right to
No,
put this
that
information out there?
But I do know that a plethora of new irrigation companies have happened since 2020. Okay? And I do know, because we've done tons of research, that the area that you come from does have a drought contingency plan and does have inventory restrictions. And so does, yes, the Banter River Authority sure does. So there's a reason y'all are coming here to irrigate here, because we do
No, that's not why we came here.
Hang on.
We came here
Well,
because
Hang on. I'm not gonna have I'm not gonna have an argument in here. This is a public meeting, not an argument session. Don't argue outside, but it will not take place in here, period. The comments that were signed up for have been done. I'm asking for a motion to adjourn.
So I'll make that, I'll second.
I have a first and a second.
Second.
So If y'all wanna stay in your argument, then get after it. But this is not the place for it.
9:41.